A lot of people. Good afternoon, lawyers. This is not new for the regulars, but welcome to the Appellate Division First Department. We have over 6 hours, 17 cases that are going to be argued today. To the extent, all I ask you is to please ask for the time that you need, not the time that you want. We have read the records in the case. We have read your briefs. We're quite familiar with your appeals, perhaps too familiar. With that, I'll begin the calendar. People versus Alexander Arias. Interesting start. Submitted. Robles versus New York City Department of Consumer Affairs. So, okay, so why don't I do 4 and 1 and 4? That way I'll give you the extra minute for rebuttal. J&T Children is submitted. Figueroa versus City of New York.
For the appellant, 10 minutes, Your Honor. For the respondent, 3 minutes, Your Honor.
Yeah, I'll give you 5 and 1 and 3. I don't think you'll need even 5 minutes. Clark versus Povella.
Defendant's appellants, request 5 and 2. Respondent, 5 minutes.
5 and 2 and 5. Bailey versus Gabrielli Truck Leasing. Appellant Gabrielli. Appellant Gabrielli Truck Leasing. Do you still wish to argue? I'll give the respondents 2 minutes, okay? And submit it. People versus Fuller. Appellant Fuller. Okay, do you wish to submit? People versus Fuller is submitted. Carter versus HP Lafayette. Let me hear from appellant first, and please keep your voices up.
I am the defendant's appellant. We request 5 and 2.
5 and 2. Respondent Carter.
Respondent,
5 and 2 on 5. Arasish versus America Honda Nissan.
Good afternoon. For appellant, 4 and 2, please.
4 and 2.
Respondent, request 6 minutes, Your Honor.
I'll give you the 6. I think you are going to need a little more time than that. People versus Watts. Okay, 6 and 1 and 5. 99th Avenue Holding versus TSI.
For the appellant, Your Honor, may I have 5 and 2?
5 and 2.
For the respondent, Your
5 and 2 and 3. Okay, Immigrant Bank versus Virgo Investment.
Good afternoon, Your Honor. For the appellate, we have 7.
Immigrant Bank, I'll give you 7 and 1, although I assume you all got the bankruptcy court order, so
Correct.
unclear to me why we're here, but I'm sure you'll explain it.
Yes, and also, Your Honor, my colleague will have to be changed. He'll be arguing.
That's right. So just so that we can save the time, I believe Mr. Gantz. Welcome. I hope you had a great trip from California. And Virgo Investment?
Here, Your Honor, for the respondents, 5 minutes, please.
Okay, so 7 and 1 and 5. Silo versus City of New York. I understand Mr. Silo or Silo may be running a bit late. Seems we've had some train difficulties today. So what I'll do is I will give him 5 and 1 and Respondent City 5. That's good? Okay. If we need more, we can take more, although I think we can deal with the issues in this case swiftly. Lambro versus New York DA's office.
Good afternoon, Your Honor, for appellant, respecting request 4 and 2.
Lambro 4 and 2. New York City DA's. 4 and 2 and 5.
Thank you.
People versus Sinstrunk. Appellant Sinstrunk.
Appellant requests 5 and 1, Your Honor.
5 and 1.
Respondent request 5.
Respondent people. What did he say?
5 minutes.
5? Okay. Miranda versus Century Waste.
Good afternoon, Your Honor. Appellant requests 5 and 2.
Appellant Century, 5 and 2. Respondent Miranda. I don't see. Do you still wish to argue?
I'll submit, Your Honor, unless there's potential that respondent is going to show up. I'm happy to.
We have not received any notice from them. I know in the Silo case we did. So I'm happy to mark it submitted.
That's fine. Thank you.
Okay. So Miranda is submitted. Did you one time? Is that? Oh, I thought that's what you were looking at me for.
Trying to be polite.
Okay. State of New York, Wilcox versus Credit Suisse. Appellant? Okay, so he didn't show up. Do you still wish to argue? Okay, so I'll mark it submitted. We good. This is our 5th time around, I think, with this case, so I think we've had enough. Cantor versus Bergdorf Goodman is withdrawn by stipulation of the parties, and Turo Perini Court is marked submitted. First case on the calendar is Robles versus New York City Department of Consumer Affairs. Just give me 1 second, Counsel.
You bet.
And you can take off your mask to argue, so.
I'm not
You're not?
vaccinated.
Okay, not just giving you the option, that's all.
I hope you all don't turn into lizards.
No, it's fine. Okay?
So may it please the court. Knights Collision Experts is one of the largest tow companies in New York City. It's been a family-owned business and has been in continuous operation since 1948. Joseph Robles, who is a petitioner in this action, is the second-generation owner of the company.
Has it been, hasn't been in operation in the last year?
Yes.
It has, okay.
I have
Yeah,
a
it's been in
question,
continuous
Counsel.
operation.
Counsel, I have a question.
Sure.
The issue now is whether the DCA determination is rational or not. Why isn't it rational for the DCA to take the position that only a licensed tow company can be approved to obtain a 10% interest in a towing company licensed for a special towing program? Why isn't that a rational position?
That's really not their position. Knights has been a participant in...
It's confusing about the position, I will give you that, but
Okay.
yes, I can tell that seems to be there.
So Knights has been a participant in the DARP, ROTO, and arterial highway towing programs since the inception of all of these programs. They've held tow licenses that predate the Department of Consumer
Counsel,
Affairs.
just to focus in, the issue is not the company, the issue is whether the individual
The transferee.
petitioner can get a transfer approved to take over the company. So the question isn't how long the company's been in its existence. The question, is it rational for the DCA to take the position that someone cannot take over this business unless they have had their own individual towing license for a year?
Excuse me for just 1 second. I'm sorry, I have to put my glasses back on. So it's not a rational decision because they failed utterly to consider the merits of the application. The transfer or proposed transferor, Joseph Robles, is trying to transfer ownership to his brother, Adam Robles. Adam Robles has worked for the company since 2006. He's been an owner and an officer since 2017.
Counsel?
Yes.
Sorry to interrupt you, but does the statutory scheme allow for DCA to exercise discretion here, or are you relying on other provisions that might require it to do so?
Our position is that pursuant to Section 20-110 of the Administrative Code, DCA has to consider the merits of this application. DCA has created instead a broad-based rule where it refuses to consider the merits of applications to transfer licenses so that a transferee receives more than 10% of ownership.
Well, Counsel, that section that you just referred to, 20-110, doesn't it require the person to have had at least a 10% interest? And that's not what happened here. Mr. Robles only had 9%, right? So how is this applicable?
Sure. 20-110 requires that anyone that proposes to transfer ownership of any licensed business, DCA licensed business, now DCWP licensed business, has to apply for pre-approval to transfer ownership to a transferee that will acquire a ownership interest, an initial ownership interest in excess of 9%. So if you...
So when you say consider, so obviously the merits of the application needs to be considered and the underlying reasons for denial or non-denial of the application has to be articulated.
That's our position. And in the administrative proceeding, this issue that DCA or DCWP brought up for the first time in the trial court, that there's endemic corruption in the tow industry, that's an argument that's, first of all, is outside of the administrative proceeding. It doesn't appear in the final determination. It wasn't addressed in any way in the administrative proceeding. And it is a broad-based rule that they're using to actually ignore the merits of applications brought by tow companies to the exclusion of other businesses, which was the reason why we requested discovery, so that we could see how other businesses are treated. There are other businesses that are quote-unquote problematic beside tow companies, including tobacco retailers, pedicab drivers.
But, Counsel, in the implementation of this statute, the legislative history would support the fact that there is, in fact, a reason that there was this fraud rampant throughout the... So why does that need to be articulated again inside the order when we already know the impetus behind it?
Okay, so DCWP points to different things in this court and in the trial court, including their own internal report that there's corruption in the tow industry. One of the reports that they detail shows that the corruption is being fostered by New York City police officers. So there's corruption among New York City police officers. It doesn't make all police officers bad. There's corruption among clergy members. It doesn't make all clergy members bad. There's corruption in city and state officials in New York especially. It doesn't make all city and state officials bad people. The problem here is that DCWP points to this, and then they specifically state that 36 tow truck companies and 29 drivers have had their licenses suspended. But they don't give any context whatsoever. Is that 1% of the tow industry? Is that half of the tow industry? This wasn't even brought up in the administrative proceeding. But in the trial court, we have no idea what percentage of the tow industry this is. These are self-serving allegations that reflect a bias on the part of the regulatory body against the industry that it regulates. And they clearly, under the circumstances here, did not consider the merits of Knight's application and the fact that—
So your dispute is not that there's no corruption in the industry. The point is that you don't know how that's related to any reason articulated by the respondents to deny the application.
Correct. And what was brought up in the trial court is there are no allegations of corruption against this company. There are no allegations of corruption, against Joseph Robles or his brother Adam Robles. Knights has a clean record. It's undisputed in the record. Also, Adam Robles has worked full-time.
Counsel, let me just ask you, doesn't the DCA say we have considered that, I mean, that's all they say, but it's not like they didn't acknowledge that you've submitted information about the family history and the history of the company, and they say, we have considered that, yet still we decide that this new owner needs to have a license for a year. Is that not what the decision said?
Well, not really, because he's not a new owner.
Okay, but I'm paraphrasing, but did they not in their decision specifically say, we have considered, without more, I give you that.
We acknowledge the long
We acknowledge
history of
that,
Knights is
right.
what it says.
So it's not.
But it doesn't, they don't address any of the merits of the application.
Okay, so your question, your beef is that there isn't enough there to see why they denied it?
Well, there are multiple issues here. Yeah, I mean, we're seeking mandamus, for the purpose of reconsideration. They had an obligation to consider the merits of the application. There's no question about it. They're passing lip service in the final determination that they acknowledge the history of Knights. Doesn't discuss any of Adam Robles, the proposed transferee's individual qualifications. The fact that he's been an owner and an officer since 2017 and has been responsible for Knight's participation in the arterial highway tow program, the DARPA road tow programs, it's not disputed. He is running the company. There's no question about it. He has never been convicted of a crime. He has never had a DCA license denied. He has been licensed since 2006. He's never received any notices of violation, notice of hearing, summons, padlock order, nothing like that. No court has ever rendered a judgment against him that is related to activity on behalf of a business he's involved with. And it's undisputed that neither Adam nor Joseph Robles nor Knights has ever been the subject of any of these investigations that DCWP is discussing in the trial court. And then again, as I mentioned, we go back to the fact that, we don't have any idea. There's no context given as to 36 tow truck companies. New York's a big city. There's clearly more than 36 tow truck companies. 29 drivers have had their licenses suspended.
Let me hear from the city. Let me hear from the city, and you have 1 minute in rebuttal.
Okay, thank you very much. I appreciate it.
May it please the court, Janet Zalian for the city. This was a rational exercise of the discretion afforded by—
But what discretion? See, part of the difficulty that I have is that there was no discretionary assessment. You sort of acknowledging some of the things that counsel is complaining you didn't evaluate, but you never said, we consider Mr. Robles's record, we've considered the application, and we exercising our discretion in evaluating that application. to deny it or wait a year. I mean, I agree you get a lot of deference from us, but you don't get a rubber stamp. You got to articulate a reason for us to be able to determine whether that reason is rational or not, right?
Well, the discretion that was developed under Section 2110 was developed with regard to the towing industry because of the problems in the towing industry and the points made in the Supreme Court and in this court about the towing industry.
But that doesn't, let me, see, part of the difficulty that I'm having is that let's acknowledge all of that. I mean, there's a good reason why you need to be careful to protect the public, from some of the corruption that's clearly there. They're not disputing the corruption. They're saying you need to determine, based on the administrative code section, you need to exercise your discretion by doing an evaluation of each application. You just cannot use a blanket rule and say, well, without having looked at your application, come back in a year after we've had an opportunity to observe or do whatever it is that you do.
Well, the question before DCWP, given the practice that it's had, is whether to make an exception to the practice regarding the towing industry. So the question is not whether
Counsel, may I interrupt you just a second and say, are you saying make it for the entire industry?
no,
or
what I'm
for
saying
this
is that the
person?
question would be,
For this tower?
well, the question would be whether for this entity to treat it differently than other towing companies.
No, but
And
you're required to do an individualized
did.
assessment of each application. You just cannot use a blanket rule and say there's corruption in the industry, therefore we develop a protocol that you got to wait a year for us to observe you doing the work or doing something else before we evaluate it.
They did acknowledge, they did
Acknowledge.
consider, right, and they considered the history of the company as described in the application. And what they decided was that they're not going to make an exception in this case because what you have here is a brand-new company. You have a
Counsel,
company...
let me ask you a question related to that. If you apply this requirement, you have to be a licensed tow company for a year before you can get this special application.
Right.
How can a person, such as this person, who's potentially worked in this special towing company for many years, and that's all he's been doing, how can he ever get the company transferred to him? Because he's already working for a special towing company. He's never going to be out there for a year running his own towing company and be able to meet the requirements you've imposed.
Well, of
So
course
that means
he would,
can never get it
because-
transferred to him?
Because the question is whether he would be able to do it. The issue is whether to allow him to do it under the existing licenses.
No, but my question is very specific. How can someone like this person who's worked for the company for years ever be able to take over the family business with this requirement in
He'd
existence?
apply for a license in his own, under the structure of the newly restructured company, where he is now the 91% owner instead of the 9% owner. And he applies for new licenses, and he waits not a very long time.
But doesn't the company have
Waits
to
a
then go
year.
out of business? You're saying the company should basically go out of business for
No,
a year?
they're not.
Because 100% of their business is this special towing. That's all they do. So if he waits a year, the company basically has to do no business for a year because that's their only business and stop operating for a year. Is that what you're saying has to happen?
Well, they actually, by the way, there are no business records to support this claim in the record. There's nothing in the record about the company's actual record or its amount of business from one thing or another. They would operate for a year as a towing company like other towing companies.
How can, I'm sorry, go ahead.
Does the regulation distinguish between a newly formed company and a company in which a transfer is being made that changes the interest?
Well, what it says is that this is a company where Adam, the proposed transferee, has not had the 10% ownership that makes him legally responsible for the company. They don't. I'm describing it as a newly restructured company because that's what it essentially is. He has now become...
Well, a newly restructured company is different than a new company.
But he has not operated with the legal responsibility for this company yet because he was carefully, the original transaction apparently was carefully developed to give these two owners, Adam and an employee named Josh Hernandez, each 9%, so that they'd be under that limit. And the question is, had they produced something in their application to explain why Adam running it solely, whether the agency could determine that Adam running it solely now would be already meeting the requirements for these very special programs which are designed to, among other things.
See, but that's precisely the kind of evaluation upon questioning that should take place. That's what I mean by an individualized assessment. He submits an application, puts in all of the information that you require. If you have questions about it, there's usually an exchange. What has Robles been doing? What has Adam been doing? What has Hernandez, he said, was the other, tell me what the nature of the restructuring is and how that's going to change the company. I assume that that's part of the evaluative process.
Well, they put in a letter as an application, and they put in the limited amount, which is the history of the company, that it's a family-run company. And it's, by the way, not a mom-and-pop company, it's a huge company. Yeah. And they did not produce any further details, and the agency is not required to supply additional inferences about that company that is not before them. They're not required to engage in a back and forth. The applicant can provide a more detailed application if they wanted to. They provided what they provided. The question is...
Is it done pursuant to an actual application that contains questions posed by your agency?
No. If the application, there's a letter from the attorney for the applicant, and there are some forms describing, I think, the amount of ownership of each of the parties. There's no...
So it's up to each individual applicant,
to
provide you the information that they think that you want.
Right, and all they said was that under Joseph's supervision, Adam had been working on the day-to-day, running the day-to-day operations.
Okay, all right. Thank you.
Thank you, Your Honors.
Thank you, Counsel.
I just have a couple of salient points. These are mischaracterizations that are made by counsel for DCWP. First, Section 20-110 of the New York City Administrative Code is certainly not unique to tow companies. It wasn't promulgated for tow companies. It's not in the tow company rules. It's a rule of general applicability to all DCWP regulated businesses. So the idea that that was promulgated to somehow punish the tow company, false. This counsel for DCWP is admitting that there is a general rule against considering the merits of these applications, which is exactly what they should not be doing. I would like to also mention, as the court is probably already aware, that in the record at pages 33 and 34, DCEA has promulgated a form, in fact, for applications to transfer ownership. That form was used by Knights, and they filled out the form, and then they submitted an appendix with additional information. And with regard to Adam Robles, he's been a licensed tow truck driver, fingerprinted since 2006. DCWP, formerly DCA, would have been aware of any arrests. They've got a history of his record. It was before them in the administrative proceeding because he's been a licensed driver since 2006 and an owner since 2017. The final thing I'll say is with regard to the transfer of 9%, when Mr. Robles, Joseph Robles, transferred ownership, he was only allowed to transfer ownership of up to 9% to Adam Robles and Josh Hernandez. If he had been able to transfer more in 2017, he may have done so then. Our argument is, and in conclusion I'll say, that implicit in Section 20-110 of the Administrative Code is an obligation on behalf of the Department of Consumer and Worker Protection to consider the merits of these applications and not to malign the industry and say, oh, there's corruption in the industry, we don't have to consider your application. A broad-based rule is absolutely not acceptable.
Okay, thank you.
Thank you very much.
Figueroa versus City of New York. You can have it.
May it please the court, Ian Ash for the appellant in this action. Our position, as obviously stated in the brief, is that there's prior written notice and that the city did not definitely prove that there was an absence of it. That's what the court said in the Sanchez case, which I argued. You have to definitely show there's no prior written notice. And they submit repair records, 9 of them, which do not specify any specific location. The information boxes for corner, for lane, for distance, for length are not filled out. They try to supplement this with an affidavit from the deputy director.
I mean, the Big Apple map that should be constituting the written notice dates back to 2003, right?
Yes.
So the accident took place in 2011.
Yes.
Were there not records introduced by the city that they had done repairs at that same area where the accident took place?
They submitted repair records. Those records do not specify the location at all.
But the affidavit that was submitted by Mr. Jones indicated the procedure when they arrived, that it would, not just the area of the pothole, but the entire block would be paved, right?
He indicated a procedure. Mr. Jones was not involved in any of these repairs. He's not listed on any of these documents. He has no personal knowledge of what was actually done. It's perfectly analogous to somebody saying, we have a cleaning procedure that we normally follow, but then not having specific knowledge that that procedure was followed. And I would say also, in the context of prior written notice laws, which are derogations of common law that are supposed to be strictly construed against the city, simply coming up with a generalized affidavit about a generalized procedure should not be able to overcome a Big Apple map. I mean, if you look at the other
Counsel,
cases,
let's talk about that for a minute, because there's an assumption here that the defect that your client fell in is the same defect that's shown on the 2003 Big Apple map.
yes.
Why do you believe you're correct on that basic point?
It's a non-transitory defect. The city presents, I mean, we're talking about exposed cobblestones that were probably installed 70 years ago, or at least. We're not talking about conditions that are transitory or transient. The city has not come forward
How
with
have
any
you shown that your client fell in the 2003 defect? I know you have an affidavit
Yes.
there, but how have you shown that?
The map indicates a defect at the exact crosswalk where the client fell. The case law on this has been uniformly that, if there are questions about whether or not a defect depicted in a map is that the defect in question, that's typically a jury question. I mean, in the Sanchez case, you had a massive lot where the defects are all the way on the upper corner, by one street, and he fell closer to another street. The court said that under the case law from Foley, from Sanchez,
Counsel,
that's a question of fact.
Aren't there a number of cases where the courts have dismissed these cases where there are a number of FITS reports that show repairs were done in the area of the Big Apple map, and therefore the city makes out the prima facie, and the cases get dismissed on the basis of those FITS reports? Hasn't that happened in a number of cases?
It happens in cases where there's very specific evidence. I distinguished each one of those. There's a case where there's a specific address where the defect was located, and the city presented evidence that that specific address was repaired. I mean, the bottom line here is that they had an opportunity to submit affidavits from these DOT work crews, from the actual work supervisors, which is what was done in one of the cases they cite, saying, hey, this is the defect. We repaired it. Mr. Jones, the affidavit they do submit, regardless of whether or not he has personal knowledge, never clarifies either the location, nor does he say that this was done in the intersection, nor does he try to say that defect was repaired in these repairs. He just says there's a general policy, that he doesn't know whether it was followed or not, nor do I find was there any corroborative evidence that such a policy exists? I mean, I don't see how that's consistent
Well,
with.
he talks about when the repair orders were generated, and then when they were closed, right?
Yes.
And the 9 repair orders pertain to that very same intersection.
They
You're saying
pertain.
they went 9 times, but they did not repair the pothole, the specific one that led to your client's accident?
We don't even have evidence that they pertain specifically to the intersection. It just says from East 145th Street to Wales Avenue. That's the extent of the location.
But that's what was listed as the
Yes.
location, right? East 145th
Yes.
Street and Wales.
And they never specify, Mr. Jones never specifies what that location means. Does that mean within the 4 corners of the intersection? He never says that it happened on this side of the intersection or in this crosswalk. And we're not talking about a building in a small discrete area. We're talking about a 4-side intersection where you could have done repairs on the north side, the south side, the east side, the west side, the center, and never touched the eastern crosswalk. And I just think under the principles, this is not definite proof. Well, thank you.
Thank you, Counsel.
Good afternoon, Your Honors. May it please the Court. Kevin Osowski on behalf of the city.
Counselor, do you agree that the plaintiff fell in the defect depicted on the 2003 map?
We don't, I think if there was a question about whether the defect that caused his accident was the one that was marked on the Big Apple map, it would create an issue of fact. We don't need to dispute that fact in order to win summary judgment here.
You don't dispute that fact?
Well, we think under either, he's sort of pleading two, or Ms. Figueroa is pleading two different theories. Under one theory, she's alleging that the same pothole that was identified in the 2003 map was never fixed despite the nine repairs in the course of 8 years to that very intersection, and that she tripped over that very pothole. Separately, she's making an argument that she tripped over over inadequate repair, and she's making that argument in the alternative. So, but under either theory, her argument fails, and summary judgment was appropriate in favor of the city. I'd like to clarify, Justice Acosta, you were correct. The affidavit here, and the business records that are in the record here clarified that the reports were done, that the repairs here were done at that intersection of East 145th and Wales Avenue. And the court need look no further than the report records themselves, which clearly distinguish between repairs that are done mid-street or between 2 streets. An example of that is on page 924 of the record, where there's a report of a repair on multiple potholes along the entire block of McClellan Street between Grant and Morris Avenue, versus intersections like the one here, and on page 935 of the record, where you have an intersection that's listed, and that's where the report is indicating that a repair occurred. And that, coupled with the DOT's employees affidavit explaining that when crews go to do these kind of repairs, they, as you can see, they get a fairly vague description of a huge pothole or one pothole at a location about 2 feet wide, sometimes just pothole. So they go to the location, they survey the area. Here it was an intersection of 2 two-lane roads at about 30 feet by 30 feet, about the size of the well here, and look for the pothole and then repair the potholes that are in their vision. And that's what the DOT employee testified to. There's no evidence in the record about that would contradict that DOT employee's testimony. And I think it's also important that the court consider the Sanchez case on which Ms. Figueroa relies. In that case, the dispute was over whether the BAM, the Big Apple map record showed that specific defect. In that case, there was no allegation that there were subsequent repairs to that area, and that alone is a reason to distinguish Sanchez.
Yeah, and even in that case, in Sanchez, the Big Apple map didn't even have a date.
I think that's right, yes. And there was also, it was an issue where there was an uneven portion of the sidewalk. It's a clearly distinguishable case from the facts at issue here.
All right.
The court has no further questions. We rest on our briefs and ask this court to affirm.
Thank you.
Just in response, I would say this court recently decided 2 cases finding Big Apple notice in cases where the Big Apple map was dated 11 years prior to the defect. In Sanchez, it was 8 years. Again, you know, this is a summary judgment motion. The city seems to think, and this is approaching this as if the principles of a summary judgment motion, which is you don't grant the motion if there's any question of an issue of fact, don't apply because they submit repair records. You could have done a dozen repairs on an entirely different side of this intersection, and they had ample opportunity. This is the thing I want to point out that I'm emphasizing, to supplement these records. They could have submitted an affidavit from someone with actual personal knowledge, like they did in the Hessler case. They submitted 2 affidavits from the crew supervisor. So, excuse me, I forgot I have my mask on. Okay. And they could have done that. They didn't. They basically chose not to submit an affidavit of anyone with personal knowledge saying, yes, when we went out there, we did the repair on the eastern side of the intersection in this crosswalk. And that's all I have.
All right. Thank you. Thank you both.
Have a good day.
Clark versus Povella.
Good afternoon, Your Honors. May it please the Court. Dean Pillarella for defendants' appellants. The trial court abused its discretion in declining to sanction plaintiff's noncompliance, and its decision in order should be reversed, whether analyzed under CPLR 3126 or spoliation doctrine. Turning first to spoliation, the trial court overlooked that defendants satisfied all elements of the spoliation doctrine so as to warrant sanctions. With respect to the duty to preserve, this court has already expressly held in Patterson that private matter from personal diaries are discoverable. This is also fully consistent with the Court of Appeals decision in Foreman, which holds that the test for discoverability is not whether the matters sought or the materials sought are private, but rather whether they're reasonably calculated to yield relevant information.
Counsel, does it matter that the information in the journals could have been, or information similar to what might have been in the journals, since it was a tool of therapy prescribed by her psychologist, that the psychologist's report would be enough for discovery purposes?
We argue in our reply that her report would not be enough. We argue that her journals are irreplaceable. They contain firsthand, unencumbered accounts of her feelings as stated in her own words. She's the arbiter of her feelings. We argue that even her psychologist's notes, yes, they're available, but they're still encumbered by Dr. Robbins' interpretation of plaintiff's feelings. This is plaintiff's feelings as stated in her own words. She also concedes in her brief at page 28 that her feelings come into play when proving her emotional psychological damages claim, and it's undisputed that she documented her feelings in her journal, so they're certainly relevant. Turning to the culpable state of mind prong under this.
Let's say we agree with you that spoliation sanctions, you know, are appropriate. What you just said, how does that affect the issue of what the remedy would be, an adverse inference versus dismissal? Because there clearly is other evidence of her psychological state other than these journal entries.
Yes.
So isn't the most that you could hope for, if you're successful in this, an adverse inference as opposed to dismissal?
Well, an adverse inference, according to the decision of Alphys versus Smith, for example, which we cite towards the end of our initial brief, is usually appropriate where there's a negligent spoliation. We contend here that
It's not just that. It's also appropriate in a situation where there is other evidence that could be used in the same situation. And here you've just conceded, and we all agree. You've got the treating psychologist's notes. So it's not like you are stuck with no evidence. So to ask for a striking of a complaint where you do have some evidence, it might not be all the evidence you're entitled to, is a pretty harsh remedy. That's, I think, what I'm struggling with. Why wouldn't an adverse inference be the appropriate thing here where you obviously have other information?
Well, an adverse inference would certainly be better than what we have now, which is nothing. And we do brief all three possibilities in our brief for the court. But there is no evidence, in our view, comparable to plaintiff's journal. So, for example, plaintiff cites this court's case of Myers. That case dealt with a list of doctors visited, medications prescribed. She cites a King Supreme trial decision. Myers actually dealt with, she cites Doe, which contained the list of doctors visited. That's not comparable, in our view, to her feelings as stated in her own words in her journal. They're irreplaceable, they're inimitable, in our view. And
So you're saying even at the position of the psychologist describing what he or she heard is insufficient, or at least cannot be balanced against the plaintiff's own account of how she was feeling and what the cost of those feelings were.
Absolutely, Your Honor. And
Okay.
in Myers, for example, that dealt with an MRI film. An MRI film could be replaced. We're not talking about a broken bone. We're talking about the plaintiff's feelings stated in her own words. That's irreplaceable.
Okay.
If there are no further questions,
I think
happy
we're
to
good.
yield to my adversary.
Thank you, counsel.
Good afternoon, Your Honors. Jason Lesnick for the respondent. The best evidence is here. They have the plaintiff. They have the plaintiff at trial. They've had her 3 times. She testified 3 times at deposition. They didn't pry into it. Her testimony was that she documented her feelings. And how she felt.
But they will have to rely, it's not the same, right? Because they will have to rely on a credibility assessment of what she testifies to, rather than what she contemporaneously jotted down in her journal, when she was feeling not well, or what the underlying reasons for feeling the way that she describes in the journal, right? So it's not the same. I mean, putting aside the policy choice that the Court of Appeals made in Foreman, I mean, we don't have a choice, right? The journals have to be treated the same way as any other documents, social media, et cetera. And it's up to the trial judge to do the balancing of the potential utility of the information that is being sought.
And the balancing, I think, Your Honor, is exactly right. And that's what the case law talks about as far as relevant matter. That's what all the cases talk about.
But what is your answer to their point is, we can cross-examine the psychologist or the plaintiff all we want, but we will never be able to get the kind of evidence that we will get by looking at the journal, because the journal reflects a present state of mind at the time that she jotted the information in the journal.
And the issue was, Your Honor, that they never moved for that from a court. They never moved and made a motion. They sent us a demand. It was a very overbroad demand in the beginning. They asked for the entire journal, and the lower courts and the appellate division does not agree with that. You cannot just turn over the entire journal. It's a matter of
But you're on notice. You're on notice. There's a demand for it. Don't you have at least, at the very least, isn't there a preservation requirement?
The issue is that the journal was lost. I mean,
Well, did she ever move for a protective order saying that she shouldn't have to disclose this journal, or for an in-camera inspection or something?
She didn't move for that, Your Honor, and the issue is that the defense never moved for it either. They never moved for that in-camera inspection.
No, but the question is, once you're put on notice by a discovery demand that this information is sought, you have an obligation to preserve it. You can't just say, lost it, right? I mean,
I totally agree.
That's like Zoom. That's,
I agree.
Right?
I agree.
And that's what she said. Lost it.
But that wasn't the case. It was the fact of her moving. It wasn't just that she purposely got rid of it. She moved. She's in a military family.
Right. So
But
that
she lost
goes
it
to
twice.
culpability, but right? That goes to what the sanction is. Not, I mean, she negligently or however lost information that she was on notice she was required to preserve. I don't think you could dispute that, right? It may have been negligent, it may not have been purposeful, but she was on notice. She had to preserve that. And in fact, I know she knew because you objected to the demand, even though then you said, and by the way, she lost it.
Yes, and in her deposition, she acknowledges that, yes, I lost it, I regained it. There was multiple
So
depositions where
there's
she
no
felt.
doubt she understood that she had the obligation to preserve it, but you're saying that she lost it negligently, which I agree is a different thing from having a culpable state of mind, but it doesn't change the fact that she lost relevant evidence.
She was on notice of that, and I think that's totally ripe for cross-examination at trial. We don't dispute that. The defense is going to argue that at trial, and that is the sanction.
So
We
why
get to make
shouldn't there be an adverse inference given at this point?
Because there already is one. They're able to cross-examine her at trial about this and make their closing summation
No,
about
but
it.
that's not the same as an adverse inference, right? That's not the same as the judge telling the jury that that information would have been prejudicial to you, and they should consider that in evaluating the rest of the evidence.
I agree, Your Honor, but the issue is that there was never any proof at her deposition that anything in there was relevant. It was feelings. The defense counsel never...
So in other words, you're going back to essentially what the trial court said, that private journals are beyond the scope of disclosure, or are you just saying it's not, that these particular journals were not material and necessary?
What I'm saying is we do not have enough information in this specific case. I'm not saying all cases, but this case, there was never enough to see what was exactly documented in those journals.
How
Well,
could
That's
there be
because
if
she lost
threw it
them.
out, though? I mean,
At her
how could
deposition.
we ever know that? It might have said, I'm suffering because of something that had absolutely nothing to do with the accident. They're never going to get an opportunity to find that out because she lost it.
After being put on notice that she should preserve them.
The issue is they could have asked her about that, and they didn't. We don't know if those journals have something to do with how she was feeling because the weather was bad that day or something else. We don't know that it's relevant to this accident. That never came out.
Okay, thank you, counsel.
Thank you, Your Honors.
A few
Counsel, what do you say to that, that there's no relevance, although she does make a claim for pain, for psychological injury? And what do you say to counsel's statement that her diaries about her treatment with maybe a psychologist for the trauma she suffered or the pain that she suffered because of this accident is not relevant?
My response is twofold. So in the Court of Appeals Foreman decision, in abrogating this court's decision of TAP, the Court of Appeals expressly rejected the proposition that a party is required to make a showing that evidence exists. The only question, right? The only question is whether or not it's reasonably calculated to yield relevant information, and it certainly is. Plaintiff concedes, again, in her brief at page 28, that her feelings are relevant. We know that her feelings are in the journal, so they're relevant. Just briefly, with respect to the argument that we never made a motion to compel, we're not required to, under whom the duty to preserve exists once litigation could reasonably be anticipated. This court has also held since Coffey in 1964 that a motion to compel is not a prerequisite to the imposition of sanctions.
Okay,
If there are no further questions, I'm happy to rest on my brief.
I think we're good. Thank you so much, both.
Thank you, Your Honors.
Bailey?
May it please the court, I'm Annette Hasapides, appearing for the plaintiff respondent in this case. The lower court properly granted summary judgment on liability as to defendant Duncan, on the defense of comparative negligence, and on the seatbelt defense, and the court also properly denied the cross motion under 3211. With respect to the liability...
I thought you were just going to say, you know, the appellant is not here, VTO 1160C, and sit down, but...
If that's what you'd like me to do, you would.
Okay, I'll let you. I mean,
no, I will not
it's
be.
so refuted that Duncan violated that section by attempting to make a left turn from the right lane, right?
Yes, yes.
That alone is dispositive. Maybe that's why they're not here.
Perhaps the Graves argument, they never established their prima facie entitlement. All right, I'm going to follow the the bench's cue and take my seat. Thank you for your time.
Thank you, counsel. Okay, Carter versus HP Lafayette. Just trying to help a little bit with the time.
Good afternoon. May it please the court, C. Briggs Johnson on behalf of the defendants' appellants. Your Honors, I think it's important to note in this case, at the outset, where plaintiff has conceded that the only structure, apparatus involved in her accident was the metal saddle, okay? So we're talking about the metal saddle. Why is that relevant? That's relevant because plaintiff and her boyfriend and the super, who have lived in this building or worked at this building for 10 years, have unequivocally testified prior to the accident that there was nothing wrong with this entrance. There was no prior accidents.
I thought the boyfriend testified that he had observed this saddle be raised for about 4 years. And in fact, prior to the plaintiff's accident, wasn't there someone else who fell? It was on the video.
So as to the first point, the saddle being raised in and of itself does not make it dangerous or defective, Your Honor, because the boyfriend...
But it goes to notice, right, for 4 years that it's been like that?
Right, but it doesn't mean that the condition is defective. And that is obviously negated by his testimony saying that he used this entrance for 2 years straight, never complained, never had a problem with the entrance. Regarding the video, I respectfully disagree. If you see it, listen, it's a boring video, okay? People coming in and out of an apartment building in the Bronx, not the best TV on planet Earth. However, no one falls, no one trips, and it does...
Excuse me.
Yes.
It's not a stumble? The video doesn't depict someone stumbling earlier that day?
Your Honor, I mean, it shows the plaintiff stumbling and falling.
Not the plaintiff. Before the plaintiff falls, does the video depict someone stumbling on the saddle or at the door?
Your Honor, I wouldn't call that a stumble.
Well,
you know,
what would you
like
call it?
Excuse me?
What would you call it?
I would call the video is skipping up, and maybe she lost her balance, as plaintiff may have done, by tripping over her own feet, but stumbling over your own feet.
But all we're looking to see if there are actually issues of fact with respect to actual notice. So I understand that sounds like an argument you would make to a jury, but why should we accept that argument on a motion for summary judgment?
I think because the mountain of evidence, including plaintiff's own testimony, when she left that building earlier that day, saying that it was broad daylight, the entrance was unobstructed, right, which goes to the trivial and open and obvious argument. No one's ever had a problem with this entrance. No one's ever said it's dangerous, okay? I mean, it may be a step up. It's an old building. 1971 it was built, but it is in full accordance with the 1968 building code, okay? And the building, you know, buildings were built differently back then. And that's something we all know. And of course the building was older, right? And the saddle maybe has been slightly bent, but it doesn't make it dangerous. Not when plaintiff, the super, and her boyfriend, who have lived there for 10 years.
But you also have competing affidavits here of experts.
No, yeah.
Hold on.
Sorry, Your
Honor.
Honor.
Finish my question.
Yeah.
Where they take measurements and lo and behold, they come to different measurements. Would that raise an issue of fact with respect to whether or not the saddle was dangerous?
Your Honor, respectfully, plaintiff's expert's affidavit is valueless, okay? He relies on building codes that were never pled, were raised for the first time in opposition to summary judgment, and which are contrary to the evidence. He says in his own affidavit that the building was built in 1971. What does that mean? That means that only the 1968 building code can apply. So all the 2014 building code, the 28 building code.
I mean, you still have, whether it was built in 1971 or in
Right.
1905.
Right.
You will still have a duty to maintain the building in a reasonable and safe condition, right?
That's fair. That's accurate. But I'm also saying that the measurements and the waviness that his expert talked about, the good and accepted building practices, there is no proof in his expert affidavit establishing what these standards are, why they should be relied on. He's actually relying on the 2014 building code and trying to tie that into good accepted engineering practices, but he never describes those. And so those can't be evidence of negligence, I guess is my point.
But how about when he says that there is actually a full inch differential? And that the expert says there is a full inch of differential there. And your argument is it's a trivial defect, correct?
Well, that's one of my arguments.
No, no, I'm
Yes.
talking about, so what you're saying, it's valueless. It isn't valueless if we accept that the expert measures and finds a full inch differential between your argument that it was a trivial defect
Right.
and the plaintiff's argument that it's a question of fact.
That's fine, and I accept that, and I understand what you're saying, but I'm saying if we look at all the evidence in combination, the lack of...
Plus, I just want to say, I did watch the video, and that
Yes.
woman did stumble. It was a clear stumble. There was like 4 minutes or 5 minutes before
Sure.
the plaintiff. It was,
Okay, well, let me qualify what I said earlier like this. There's 8 people that go across this entrance. Nobody else stumbles and falls. She may have had a little stumble, but we also don't know whether or not she tripped over the entrance of her own feet.
I know that's exactly why that is not summary, that's not
That's what
summary
trials are
judgment,
for.
though. That's trial.
Sure, and assuming everything you said is true, which, and obviously it's respondent's term, in my 2 minutes of rebuttal, I will talk about the no notice and no creation arguments as well.
Okay.
Thank you.
Good afternoon. If it may please the court, on behalf of respondent, and we've just heard a great and probably proper argument to make to a jury. However, this is not an argument for summary judgment. And I also like to address something that was said as to the actual physical condition of what the plaintiff alleges that she tripped over. The physical condition of it is not in dispute. And in fact, it is, you'll see on page 413 of the record that it is defendant's expert who measures it and says there's over a 1-inch deviation. It's not in dispute that this was a over 1-inch deviation. It's not in dispute that there was a wave in it. Again, these are photographs that were attached to the defendant's expert's report.
And counsel, let me just ask you, was there also, I was unclear, there is a non-party witness who says, and it was like that for a long time, 3 or 4 years.
Correct.
Correct?
And not only that.
So the question then is that constructive notice of the defect?
Correct. Not only that, though, but the witness for the defendant, the superintendent, testified that that is the condition it's been in since he got hired, that he inspects that area twice a day. That's the condition of it. He was shown the photograph. He says that's the condition of it at the time of his deposition, is the condition of it on the date that the plaintiff fell. That was the condition of it the date he was hired, years before. They have actual notice of the condition. Their argument is merely that it's not a dangerous condition. That's a question of fact for the jury. We have an expert who testified that it was a dangerous condition. We have the photographs. We have a video. We have, as was pointed out, the video even shows someone else stumbling over it, and it was approximately 20 minutes before plaintiff then falls. And again, these are all issues that go to notice. So in regard to constructive notice, I don't think we even need to discuss that because there's actual notice that's admitted by defendant in his deposition. And again, that would be on page 302 of the record. Thank you.
Thank you.
Your Honors, I'll be brief. Like I said when I started, plaintiff is claiming that the metal saddle is raised, right? That it lifted up.
No, he's not claiming that. You keep saying that. Your expert admitted that that's the case.
Right, and that's plaintiff's plaintiff's testified at her deposition, right? That the metal saddle was lifted up. That caused her accident, right? But earlier on in that deposition, she says that it wasn't lifted up, that her foot hit it.
But your own expert says that it's, I don't know why we're discussing this. Your own expert says it was raised.
Right, but what I'm saying is the only evidence showing that the metal saddle was lifted up was from 3 days after the accident when plaintiff was shown photos taken by an investigator hired by her attorneys saying, oh, yes, this was lifted up. But when she testified at the earlier...
So it got raised an inch after the accident?
I'm saying that to assert probative value to the metal saddle being lifted up, The only evidence in the record that is lifted up is based on photos plaintiff was showed 3 days after the accident.
What about the super, or, I mean, the boyfriend said that for 4
3 or
years,
4
right, it
years.
was lifted up? Isn't that raise an issue of fact?
But I guess my point being, and I understand where the court is going, okay, is that if the boyfriend used the entrance for 2 years and he never complained about it and he never had any prior accidents.
So it's not that it wasn't raised an inch, but it's that nobody was complaining about it.
Well, that goes to constructive notice. That goes to actual notice. That's part of the inquiry. And
But you were on notice of the condition. The question is whether it was a defective condition, that creates a violation of your duty to keep.
whether it's dangerous or not, right? And I think the mountain of evidence of the testimony shows that it's not dangerous. I understand that is not a popular argument at this time. I think the court.
I mean, we have a role to play.
Oh, absolutely.
So do juries.
And I understand it, and I understand everything the court is saying, and I appreciate the court's time, and I will see you guys tomorrow. Have a good day.
Thank you. Arasish? You can have it.
Good afternoon. May it please the court. Dan Gagliardi for Appellant. So the main issue, well, the two issues on this appeal are, it's a causation appeal in an asbestos personal injury case. The trial court found that issues of fact existed regarding the expert evidence, but our position is that Nissan made two prima facie showings that its products did not cause or contribute to the decedent's injuries.
Counsel, does Dr. Feingold specifically state that the plaintiff's, or the decedent's EGFR mutation caused his cancer?
Yes, he does.
He does that specifically? So could you quote me the language where he says, within a reasonable degree of medical certainty, that that was what the cause was?
So on 768 of the record, paragraph 19 in conclusion, and I'm sorry, it's kind of a big paragraph, but it's about...
Just read me the language.
Oh, sure.
What was the paragraph?
Paragraph 19.
19?
He says, he first suffered from a de novo EGFR driver mutation-induced small cell lung cancer.
That's what I read.
So there he's saying that it did cause the small cell lung cancer?
But it's not really saying that, right? We're inferring that, because he also says in his, one of his opinions is that there are no reports that connect this particular mutation to small cell carcinoma, correct?
Well, he says
Is that correct?
No, he does say there was a couple of de novo small cells, but
He doesn't
that
say,
specific
quote,
exon
there have
mutation.
been no reports? He doesn't say that?
He says that of the very few other cases of small cell, de novo small cells, that there was a different exon mutation. There was an exon 19 and an exon 21.
So what are the odds? Is it 1 in 1,000, 1 in a million, that this particular mutation will cause a small cell carcinoma?
I could not tell you the odds.
It's very rare, right?
Yes. I'm sorry, it just
Very rare, correct?
Yes.
So, counsel, let me ask you this. Did he come to a conclusion with a reasonable degree of medical certainty that the asbestos disclosure, the exposure, did not cause the cancer?
Yes.
Right? And he said that straight out, correct?
Yeah, he says that multiple times.
And what's the basis for that conclusion?
Well, it's two, and I'm sorry, just another time where he says that it was caused by the EGFR mutation is on 764 of the record.
Okay.
Paragraph 9, the finding of the exon 20 mutation in Mr. Arasich's tumor is extraordinary because almost all lung cancers caused by EGFR driver mutations are adenocarcinomas.
He doesn't seem to be exactly saying it, right? Wouldn't it be simple to say it if he was really saying it?
And I think he's saying it there at both of those times, and that's why he's talking about this EGFR mutation. I think it's also worth noting that plaintiff does not ever dispute this conclusion or put in anything saying.
Well, the issue is whether or not you made a prima facie, and that's what you're arguing. You made out a prima facie.
Right, so it would be that there is this unique mutation, and there is a study showing that people who are exposed to asbestos, never smokers, with asbestos exposure actually have a far lower rate of this mutation. This mutation more typically occurs in non-asbestos exposed never smokers.
Counsel, going back to paragraph 19, where he references that Mr. Arsich died of a very rare, essentially unique malignancy, which had nothing to do with asbestos exposure and certainly was entirely unrelated to his history of work as an automotive mechanic. Other than that conclusory sentence, was there anything else in his report that supported that?
The EGFR mutation or the, because it's really, it's a two opinions. First is there is this specific mutation, and this specific mutation is not related at all to asbestos exposure. And then he has a more general opinion about insufficient exposure to have caused it, which isn't related to the EGFR mutation. If it was another lung cancer, you could have that opinion.
So with respect to specific causation, you have to show under Nemeth, or plaintiff has to show under Nemeth at trial, plaintiff was exposed to sufficient levels of asbestos to cause the illness. How have you shown, in fact, that he wasn't exposed to any asbestos? The gentleman in his deposition says that although he was a mechanic, he did work during periods of time on breaks, sometimes as much as 2-3 times a week. And isn't it correct that there is asbestos that comes from breaks?
Yeah, we weren't disputing, and he was also an asbestos insulator for.
So you're not disputing that part?
No, certainly.
So your argument then, as I understand it, and I apologize.
Sorry.
It's probably me, is really you're saying that it was, that he died because of this very rare form of cancer caused by this genetic mutation. Is that the primary argument?
Yeah, well, and then there was the second argument was a more general.
And what was the second argument?
The second argument was based on Dr. Feingold, but also Drs. Robbins and Hardin's opinions that vehicle mechanics, the types of exposures that vehicle mechanics encounter, do not increase the chance of lung cancer.
That's accurate, but with respect to mechanics who work on brakes, are there studies that correlate asbestos with brake work? And here wasn't plaintiff working on brakes, we can go through the record, but wasn't he working on brakes?
Yes. Yes, he was.
So do you concede that a brake mechanic or a mechanic who works on brakes could potentially suffer or get asbestos exposure?
Yes, no, it's not about whether or not he was exposed to this, but we didn't make arguments that he wasn't exposed, that he didn't allege exposure to asbestos. They're causation arguments.
Well, then how did you make out your causation on, with respect to specific causation? How did you negate causation?
I think we did it two ways. First, we spoke about the EGFR mutation.
Okay, got it.
And specifically that is not related. So it could be caused by asbestos. If he has a lung cancer, that's not caused by asbestos. And then secondly, the types of exposures he encountered as a vehicle mechanic, and this is our IH and our toxicologist, they don't, and there's studies showing no excess cancers, lung cancers among vehicle mechanics.
Is there any evidence that he used brakes more or less than any general vehicle mechanic? Was that one of the discussions or arguments in these papers, that this was a mechanic who worked more with brakes than most mechanics? Or is the evidence just he was a mechanic and he worked on all kinds of things as a mechanic, including brakes?
Well, he wasn't using exclusively Nissan products either. It was one of,
That wasn't my
he listed
question.
all the things.
My
Okay.
question, is there any particular emphasis on this case as him as a mechanic who works on brakes, or just that he's a mechanic who does what all mechanics do?
Yeah, no, he didn't just work on brakes. He worked on other items too. And Dr. Robbins.
So what did he testify to in his deposition? Did he, for example, testify at record page 101 that he would perform 2 to 3 brake jobs per week, at other times 1 to 2 brake jobs per week, and then at other times performing multiple brake jobs per week? So would that be a fair characterization of his testimony?
With regard to brakes generally?
Working brakes, right.
Yeah.
But let me ask you this, is that he said, he didn't say anything, that's all I did, right? He was a mechanic, he worked on brakes, he worked on ball joints, he worked on everything else, right?
Yes.
So there wasn't he wasn't a specialist in working on brakes.
No, no, that wasn't.
Okay.
Thank you, Counsel.
Thank you.
Thank you, Your Honor. Alani Glansky for the plaintiff.
Can I ask you the same question that we were just focusing on with opposing counsel? Is there any record in this case that he had any special emphasis in his mechanic work, working on brakes, more than other mechanics generally who worked as mechanics?
He had
Or any
substantial.
arguments you made specifically having to do with brakes versus other automobile parts?
There is evidence here that he worked significantly not only on brakes, but on the asbestos-containing clutches and gaskets, and he gave quantifiable figures about that sort of work. 2 times a week on engine gaskets, at least with calculable time periods that each job would take, both ripping off gaskets and putting them on, replace clutches at least 2 times a week with calculable times that those jobs would take, and more than one brake job every single day for numerous years throughout the 1970s.
Was his work different than the work? Is there any evidence that the work he did was different than the work that any vehicle mechanic would generally do as a vehicle mechanic?
Well, that's an interesting question because...
I'm asking that question because they've put forth studies that vehicle mechanics generally do not have an increased chance of getting lung cancer from asbestos. So,
yes.
So that's why I'm focusing on that. Is there some evidence that he was somehow different than any other vehicle mechanic in the work that he did?
I think the way to look at that issue, Your Honor, is that there is no evidence that those studies dealing generally with vehicle mechanics had anything to do with asbestos exposures. Now, I can specifically speak to that in that their toxicology...
I'm sorry, the epidemiological studies
yes.
that indicate that auto mechanics generally do not have an increased chance of lung cancer. How could
Yes.
that not have to do with asbestos? That's what it's saying, that your argument is that the asbestos in these products cause lung cancer. So if there's an epidemiological study that says vehicle mechanics do not epidemiologically have an increased chance of lung cancer, why wouldn't that go to the question of asbestos?
Your Honor, their toxicologist, Hardin, was a very highly qualified and experienced scientist. He was the former deputy director of NIOSH, who did risk assessments that then it went into the OSHA standards. This is not the usual sort of case where the plaintiff puts forward an OSHA standard. This is their own toxicologist. Now, that toxicologist cites to the 1994 OSHA final rule, and specifically to Table 5 in that OSHA final rule, which the court can take judicial notice of. It's published. And he says for auto repair, there's a very small fiber per cc exposure level. Now, he omits that in that table, there is an entirely different fiber per cc level for work with asbestos friction materials. Now, once you're working with asbestos friction materials, friction means automotive repair, but including asbestos work. Their proffer was that there were certain fiber per cc calculations from vehicle work, and the plaintiff specifically rebutted those proffers by showing that there were multiples higher fiber per cc fiber releases in the breathing zone of the worker.
Are you suggesting then that they made out their prima facie, but you rebutted it with what you put forth to contradict it? Is that what you're suggesting?
I don't believe they made out a prima facie case, particularly in the context of the recent floor tile decisions by this court, in which this court credited the defendant's scientist's proffer that the dose based on the testimony and based on the studies was less than what is required to show, to sufficiently
But the
cause.
case wasn't, I think that's kind of unfair, because the case wasn't really argued under the Nemeth standards, just how Nemeth came down.
Yes.
So going back originally to the really, I think their primary and probably best argument that he died because of this mutation which caused a small cell carcinoma. Can you address that argument?
Yes, Your Honor. The question is whether the plaintiff's experts and the evidence.
Well, do they
in the
make out a
record-
prima facie first?
They did not make a prima facie case because there's an analytic gap in Dr. Feingold's presentation of that, where all he says, the most he says, is that the EGFR mutation accounts for a large proportion of the lung cancers in people like the plaintiff. A large proportion is exactly the sort of generalized language that this
So
court has
counsel, let me ask you, what expert did you put forth that specifically disputed that finding?
Yes, Your Honor. Well, so the dispute was that.
I'm just, again, what expert did you put forth to specifically dispute the defendant's expert's testimony that in a reasonable, with a reasonable degree of medical certainty, he died, he suffered from a de novo EGFR driver mutation, asbestos exposure did not increase that, the patient had minimal plaque and didn't have asbestosis and therefore did asbestos. What expert opinion did you put forth that specifically dealt with that finding?
I would really like to answer that specifically.
Yes.
And the answer is, first of all, their pulmonologist, Feingold, making that argument, cites over the course of 30 pages from 734 in the record to 766, his reliance on Penny Nymark's scientific studies. Penny Nymark is also cited by the plaintiff's experts. And what Penny Nymark says is
so just tell me what portion of what expert's testimony specifically addressed that finding. That's all. Because we don't have a lot of time. I'll go back
the
to
defendant's own expert relies on Penny Nymark, who says that asbestos is
Again, I'm going to ask you, did any of your experts say that conclusion is wrong and here's why?
Okay, I'll switch to this. At the record at page 1015, Dr. Ginsburg says that the asbestos fibers causes the genetic damage and cites 13 studies to that effect, including mechanisms of fiber-induced genotoxicity.
No, I'm talking about the de novo EFGR driver.
Yes, Dr. Ginsburg lists the EGFR driver as one of the mutations that is being discussed, including the EGFR at 1005 in the record.
1005? Okay,
1005, he lists the EGFR as one of the mutations. He says asbestos fibers causes the genetic mutations, and then Dr. Staggs separately at 1029 through 30 says, provides the mechanism by which that happens. The asbestos inhalation causes the inflammation, which causes the mutation, which causes the lung cancer.
Okay, thank you.
Thank you, Your Honor. If there are any further questions?
I think we're good. Thank you, Counsel.
Thank you, Your Honor.
And counsel, I'm going to ask you, do you agree that plaintiff's experts specifically addressed Dr. Feingold's opinion in that regard?
No, I do not. The citation at page 1005 is just Dr. Ginsburg repeating results of a lab report. And then he just gives general opinions. Asbestos can cause genetic mutations. That would mean if you ever have a cancer with a genetic mutation and you have asbestos exposure, under Dr. Ginsburg's opinion, even if it was pancreatic cancer, prostate cancer, something that has no relation to asbestos, you could say, well, there's a genetic mutation and there was asbestos exposure and asbestos causes genetic mutations. And we can't do that anymore after Nemeth. We need specific opinions about it. It's not enough to say toxin causes disease, there's exposure to the toxin, person has the disease, substantial factor. And that's what they're trying to do here.
So now going back to the studies with respect to mechanics, your adversary says that there are specific studies with mechanics, rather than characterizing them as brake mechanics or other, but mechanics who are engaged in friction materials, there's a release of asbestos. Is that an incorrect statement? And was, as a follow-up, was plaintiff involved in replacing friction parts of vehicles?
Yes, like brakes and clutches. He was involved in friction work.
And is there a correlation between mechanics who work on those particular parts and asbestos release?
You know, I think it's a bit dangerous sometimes when lawyers try to play IH and epidemiologist. We have a very well-qualified IH and epidemiologist who said, this is the proper cohort to put him in, this is the type of work he did, and the studies say that you don't see an increased lung cancer, and they had asbestos exposure. So if asbestos, the type of asbestos exposures that they had caused lung cancer, you would see an increased lung cancer in those things.
I understood that the study that was done separates regular mechanics. That's the question that was being asked by Justice Kern. Okay. There's a difference between someone who just does general mechanical work and somebody who does brake work or work on friction material.
I believe that.
And there are different parts, the different measurements of it, right?
Yeah, well, I mean, some of the studies that plaintiff spoke about in the brief, such as, for example, there's a time where plaintiff takes issue with a study cited by Dr. Robbins that says in the Ben Hamou French study, Dr. Robbins says that there's no showing of excess lung cancers in motor vehicle mechanics in that study. Plaintiff says, oh, actually, there was a showing of excess of 1.42. This study isn't in the record, I had to print it out, of 1.42. For, you know, where you would see one is baseline. There's 1.42 cases of lung cancer among motor vehicle, people with motor vehicle work. Except, if you look at the actual Ben Hamou study, that's in motor vehicle drivers. It's the people who drove the trucks, and she attributes it to the fact that they have diesel exposure. And it does have motor vehicle mechanics in that study, and it's 1.06 and not statistically significant. So this is why the IH and the epidemiologists look at it. And when lawyers, and again, in the briefs, we have a lot of
that's why the expert
pathological arguments.
But that also is the argument for why this expert should be testifying before a jury, rather than have lawyers and judges make epidemiological choices about what constitutes. I mean, it's more than a legal issue, I guess is what I'm arguing.
I think, though, the standard in summary judgment is just to show at first impression that you have a case for summary judgment. And I think what we put in there from these expert reports is enough. And what they put in to rebut those, because, and I'm going to also note that in plaintiff's brief at page 3, plaintiff says, the trial court correctly concluded that this was a case for the jury to decide which expert was credible, which means we did make the prima facie showing, and they had to rebut it. And this court's recent decisions in Dyer, which these are almost the same opinions given by Dr. Ginsburg and Dr. Staggs. It's the same. No, they don't give a threshold. They say no safe level.
But wait a minute. In the tile cases, essentially the finding was that the dust that came out was within sort of acceptable ambient levels. Is there anything like that in your experts' opinions, that what was being released from friction materials of Nissan products, Nissan and Datsun products, was within acceptable levels?
Yes, you know, they're long reports, so I don't have.
And if you do have that, I would like to know at what record page that appears.
You could look at record 459, Roman 11, vehicle mechanics is one area.
Vehicle mechanics.
Yes.
Again. So you rely on the general studies, right? I'm talking about with respect to the Nissan Datsun products that may have released asbestos. Do you say that those were within ambient levels as the tile cases do? Because that's how you
No,
make out a
it
prima
wasn't,
facie.
we didn't make an ambient level.
No, you didn't. You didn't make that argument because you're really not arguing Nemeth. Because
Well,
Nemeth
we're
came
not
down
arguing.
later.
I guess my point was more this. We did, in another way, showed that we did not cause the plaintiff's injuries, and under those cases, what they put back in just isn't sufficient to show anything.
And you show it, you say, based on the fact that, in fact, that he died of this rare genetic mutation, which caused, got it.
Yeah, that and the vehicle. Even if it wasn't for the rare genetic mutation, though, we would still have a showing based on the vehicle.
But you've also
mechanics
acknowledged,
studies.
though, that there is a difference with friction materials, correct?
Yeah, well, I believe generally the mechanics would work with friction materials in those studies.
That's what I'm unclear about. Are you, is there a study that splits out friction as opposed to mechanic work?
Well, look, for example, if you look at 459, there is talk about specific levels from work with, well, the general studies showing no lung cancer are just looking at the populations of.
And so when your epidemiologist says this person fits into this group.
Yeah, and the IH.
And they've given their reasons why they think that is, correct? And
Yes.
is there any indication on the record that Nissan cars are any different than any other car?
No, I don't think there's any.
So when we say automobile studies, that would include Nissan cars, correct?
Just as you could work with a piece of floor tile and one study to another, it's a pretty standard.
But I thought the OSHA study differentiated between regular mechanics and those mechanics that work on friction material. Or did I just mishear the last 20 minutes?
You know, I'm just not familiar. I don't, was that, maybe if that was.
No, there was.
I don't have that one. Okay. I know he said that. I don't know every study. I apologize.
Okay, no, that's fine. Neither do we. So.
Okay. Thank you very much.
Thank you both. People versus Watts.
May it please the court, my name is Angie Louie for the appellant Darrell Watts. Here, Mr. Watts was unable to meaningfully participate in his SOAR risk level determination hearing.
Counsel, can you tell me how the case of People v. Paris, how does it apply or not apply to your client's request for a competency hearing?
Well, first of all, this is an issue of first impression for this court, and the Court of Appeals has not weighed in on this issue yet. But I would like to point out that in Paris, the Second Department even recognizes that where mental competency is at issue at a SOAR hearing, that is a problem. The remedy that it crafted, however, is something that we're asking the court not to follow. Because what goes on in Paris is that instead of remanding back for a competency hearing, it barges forward with the SOAR risk level determination, thereby overriding the due process protections that are afforded.
So counsel, are you suggesting that your client should remain incarcerated longer than his sentence?
No, Your Honor,
So what if they
not.
can't do that hearing within, I mean, there's like, I think it's supposed to be done within 30 or 60 or 2 months before the person gets released. So what is your solution if they can't do so your solution is we let the person leave incarceration without a SOAR hearing at all?
Well, first, Your Honor, in this specific case, we're asking for...
No, I just want to know in general, is that what you are suggesting would be the solution if they couldn't get the SOAR hearing done within the time period that's left?
No, Your Honor, actually...
What would you suggest?
That's a difficult question, and if you ask me...
Well, do you agree with the Second Department with respect to the need to just then later do a de novo SORA risk assessment?
I do not, Your Honor, and the reason is because what the second department does is it presumes that you can go forward, but it overrides the protections. It still has the hearings without giving and affording the registrant the due process protection of meaningfully being able to
Until the defendant understands the nature of SORA, right?
Exactly, and not only just understand the nature of what's going on there, but actually an important part of SORA is being able to assist his attorney at the hearing.
So if
And-
someone is being held because their competency is an issue in perpetuity, does that mean that they would never be classified?
No, Your Honor, and this is merely a suggestion for the court, but there are certain instances where we do not dispute that Mr. Watts must register as a sex offender. What we are disputing is the risk level designation. And there are many instances where registrants have to register but are not yet designated a risk level. For example, when a registrant is coming from an out-of-state jurisdiction or when a registrant is being released from federal custody, what happens is that they must register as a sex offender, but until they have their SORA hearing, they are not given a risk level. And we would
How
ask...
do you determine what the restrictions are on them? I mean, the whole idea of SORA is that we are going to quickly get a designation going forward, and you're asking us to create a system where he could be incompetent for years, and then we don't have any designation, any rules about what he can and cannot do in his life going forward. And it seems that that's creating a situation that SORA was designed specifically to avoid.
Well, actually, under Correction Law 168F, the legislature has already contemplated a situation where someone must register but has not yet been given a risk level determination. And indeed, in People v. Gregory, which is a Fourth Department case, it's not about mental competency, it's about latches. But the Fourth Department determines that it's unfair to hold a risk SORA level determination 11 years after the registrant should have been notified. So what the Fourth Department does is it allows the person, the registrant in People v. Gregory, to come out, to have to register as a sex offender, but not be given a level designation.
But again, each level has very different rules about what the person can or can't do. And if they don't get a level, then it's totally unclear what restrictions are being placed upon them, which seems to be creating not the situation SORA was designed to create.
But that is also exactly why due process protections are extremely important here and why it's extremely important.
But the remedy of when in fact they do become competent, they can request and be given a de novo SORA hearing, and then the classification again can be challenged or questioned or affirmed or whatever the case may be.
Excuse me, Your Honor, but Paris in the Second Department, it doesn't solve the issue that the registrant will still be labeled under a level as a sex offender, given these restrictions, but without being able to fully understand, to meaningfully participate.
But that could go on for years, and that's what sort of my colleagues are getting at. It just doesn't seem like it's a workable system of what SORA is intended to protect. How is the community protected if we don't know what the level is?
SORA has two purposes. The first is it is community protection, but the other is notification of the burdens for the registrants. But it's not meaningful if the person who is supposed to register with these burdens don't understand what's going on.
So then would your suggestion be that they are just labeled a sex offender and not classified 1, 2, or 3? Or would you classify them as 1 and then think about it later? Because I don't think that's what the corrections law contemplates.
The correction law under 168F contemplates a situation where there is no designation, and essentially what happens is that the burden is like as a level 1, but just without a designation. So they still must report to and allow law enforcement to know where they are, change of address, etc. Therefore, it fulfills
right,
the
but the notification to the community is what differs between the levels 1 and 2, right? And 2 and 3, for that matter.
Exactly, Your Honor. Right. But that is also illustrates why it's extremely important because of this label, because of the liberty interests here, and the liberty interests that interplay with Sarah, that the registrant must be mentally competent and able to meet.
But we have, in the mental hygiene law, we often have people who are mentally incompetent, who are given medication involuntarily, who are retained involuntarily. They have counsel. That's how that's exactly what happens here. Well, they have counsel, so there is some protection for a person who's not mentally incompetent, and you have to make that balance. In the mental hygiene law, we do it all the time and say, well, the person has legal counsel, and we're going to hold them against their will, and their legal counsel represents their interests, even though they are not mentally competent. So in a civil proceeding like this is not the same as a criminal proceeding, right? And there are other instances where we do exactly the same thing.
To respond, Your Honor, in the mental hygiene law, in those hearings, in these civil commitment hearings under mental hygiene, there's more that's encompassed, more protections. Therapists, psychiatrists, doctors are all brought in. Here,
no, they testify. I mean, I've done them. I've done the hearings myself. I think others on this bench have too. They testify for sure, but that's the same thing that happens at the SORA hearing, that there's testimony, there's evidence that's put in. The person is represented by counsel. So it's not that there's no protection of he, she, or theirs right. It's just that this is the best compromise that we can come up with until the person is mentally competent. And we do the same thing in the mental hygiene law.
But to just respond to that, to call a SORA hearing purely civil is not correct.
Fair enough.
It is a hybrid of criminal
The way I think that
and
mental
civil
hygiene law is
proceedings.
not purely civil.
And so there must be due process protections within it. And under Doe v. Pataki, the courts have said, you know what, if you look at the SORA scheme, that's okay as an individualized assessment, but that's because there are protections put into the correction law. However, those protections are rendered completely meaningless when the person is mentally incompetent to participate. Thank you.
Okay.
Good afternoon, Your Honors. May it please the Court, Assistant District Attorney Josh Weiss from the Bronx District Attorney's Office. Your Honors, the SORA Court properly exercised its discretion in denying defendant's request for a competency hearing.
I'm sorry, go ahead.
No, why do you think that? I mean, you've heard the questioning with respect to the importance of a classification hearing, right?
Yes, Your Honor.
If you cannot get to the classification hearing because the defendant is incompetent, how can that be a provident exercise of discretion on the part of the judge if we can't get to the very thing that we need in order to protect the community and protect defendant?
Well, Your Honor, as the Second Department held in the Paris case, the corrections law does not authorize competency evaluations. There are a panoply of due process rights.
But it doesn't prevent it.
No, Your Honor, but I do believe it is clear that the corrections law does not contemplate the issue of competency. For instance, my adversary referenced the registration requirements that are embedded in 168F, which speak to the offender's responsibility to register, to notify the division of any change of address, change of employment, or change of enrollment status at an institution of higher education. That requirement, that registration requirement exists independent of the SORA hearing. That a defendant is under that requirement before the hearing even takes place. So I think that evinces that the legislature does not contemplate a defendant's competency. And while the Second Department was rightfully concerned about the absence of a provision to deal with the situation, and certainly my office is sensitive to the concerns raised by the defendant, it would be improper from a separation of power standpoint to read a requirement into the statute that the legislature deliberately chose to exclude. It's also worth pointing out
I'm not
that
so sure that they deliberately did anything. I mean, they talked about the importance of having a classification hearing, because that's really the only way that the community can be protected. And at the same time, the due process is extended to the defendant. But if that defendant is not competent, how do you get there?
Well, Your Honor, just to take a step back at the moment.
Let me just ask you a question. Is it enough for due process that the person has a lawyer, that there's been an independent evaluation, and regardless of their competency, is that at least enough minimal due process to go forward until the person retains or comes back to competency and can assist in their defense?
Yes, Your Honor, that should be sufficient in addition to the litany of rights that are enumerated in 160N.
Because we're not asking the person to represent themselves, right, in the SORA hearing. There's always going to be a lawyer for that person, even if the person's mentally incompetent. And there are records, there are other ways of there's the pre-sentence report and everything else that the board is looking at when they make their assessment, correct? It doesn't
Yes, Your Honor.
particularly have to do with the defendant's testimony or his contribution.
Yes, Your Honor, and it's also important to note that a lawyer isn't the only procedural safeguard that a defendant receives at such a hearing. In addition, the defendant has there's an elevated burden placed on the people. He's entitled to pre-hearing discovery, a statement of the purpose of the hearing.
But that requires that he communicate with his lawyer, right? So as in this case, this specific case, for the judge to just simply say, oh, notwithstanding the vacant stare, and this is during the SORA hearing, the vacant stare and the defendant did not appear to say a word to his lawyer. So clearly there's a question as to whether he's really communicating with his lawyer in order to be properly represented. Notwithstanding all of that, we don't need a hearing. My discretion.
Well, Your Honor, I see my red light is on, but if you allow me, I'd like to make one quick point.
I'll allow you, is my question.
Thank you, Your Honor. Well, Your Honor, it's important to note that there was no evidence presented to the SORA court that the defendant was mentally ill at the time of the SORA hearing. At one of the court dates, about 2 months.
Wasn't he committed at that point? He was in a facility, and they brought him from that facility? Because the case was adjourned twice.
No, that's 100% correct, Your Honor. Except there were no medical records offered or any evidence relating to the defendant's present mental state. And in fact, this notwithstanding Judge Kiesel's observation that the defendant had a vacant stare on her face, in denying his application for a downward departure, she noted the paucity of evidence with respect to defendant's present mental state. So for all these reasons, we ask that the court affirm the order of the SORA court adjudicating defendant a level 2 offender.
Thank you, counsel.
Thank you, Your Honors.
So, counsel, what was the evidence with respect to the mental state of the defendant in this case?
Well, I'd like to point out, first of all, in these proceedings with SORA hearings, in order to get medical records, we do need the client's or our client's releases. And if the person is unable to understand what is going on and unable to assist the attorney, we are unable to get these releases. So that's number one, and it illustrates why this was so important to understand that. But secondly,
Wait, are you saying that you asked for those documents, the attorney asked for the documents and the client was unable to sign a HIPAA release?
I'm not sure about that, but I'm just saying generally what happens.
But you need the defendant's cooperation and consent.
Exactly.
And you cannot consent if you're not mentally competent.
Exactly, and it's not just for medical records, it's for prison records, trial files, just anything, we would need their consent. But second, there was on the record evidence that our client was under Article 9 commitment at the time of the hearing. He was 730'd on and off during the proceedings of the case. And this is exactly why our ask today is for a remand for a competency hearing, because what the court should have done was do a competency hearing. And just briefly, The district attorney's office says that SORA, the
Well, let me
correctional-
ask you this question. If it's remanded for a competency hearing, and again, he's unable to participate because he might be in a commitment, then what? What happens then?
then I would suggest.
We wait, or do we now go forward?
That we wait. And
Until when?
until he is found competent.
And when was, and not when will that happen, but that could be, again, an indefinite amount of time.
And in the
And we're right
meantime-
back where we started.
And in the meantime, he's still required to register as a sex offender. The law enforcement would know exactly where he is, and his due process rights would not be violated because when he is found competent, then he will be able
But
to.
the competency hearing would necessarily, I mean, you say he was 7:30, right? So the competency hearing would at least involve an evaluation on the part of a mental health expert with respect to his, what's the deal with the vacant stare and his inability to cooperate with his lawyer?
Yes,
You'll be able to get at that, right?
exactly, Your Honor. And if there are no further questions.
No, we're good. Thank you.
Thank you.
Ninety-Ninth Avenue Holding? Just give me 1 second, Counsel. Okay.
Good afternoon, Your Honors. My name is Rob Chester for the appellant. This is a case basically where the plaintiff has improperly reframed what they pled as a specific performance claim in their operative complaint into a brand-new breach of contract claim.
But is that a fair characterization? Couldn't one argue that if you can't get specific performance, the law then may provide for compensatory damages if appropriate?
Absolutely, Your Honor, and I believe...
So why wouldn't that be an appropriate remedy if specific performance, as here, is not available?
Because, Your Honor, for the specific reason that you can have that remedy in many different forms. It can be an order to specifically perform, to sign something, to deliver something, to sign a lease. It can be awarded in the form of compensatory damages, but you still must plead and prove a prima facie case for breach of contract, and that is what the plaintiff here failed to do. If we look in the record at the amended complaint where a...
But I'm not getting it, because I thought that as long as there's a remedy at law, you will not be entitled to get specific performance or any equitable remedy, right?
We agree.
That's book law, right? Or did I misremember that from law school?
We agree with you, Your Honor, and we cite to a few cases which are directly relevant here. So just to take a step back, what we're talking about here is a claim for specific performance of an asset purchase agreement. That agreement terminated by its terms in 2018. That agreement said in one paragraph of it that in connection with the sale of a business, that the defendant had to take over by way of an assignment of lease, a lease with a third-party landlord. So what was pleaded in the complaint was specific performance, not a breach of contract claim, notably, but merely a specific performance claim, which we allege is defective in and of its own right, but a specific performance claim for an asset purchase agreement that had already expired or been discharged.
So let me understand this. So what you're saying is you weren't on notice that there was an assignment agreement and that the claim here is that there was a breach of that agreement. You were not on notice of that claim?
That's one of the key defects, Your Honor.
Were you on notice? Can you say in good faith that your client was not on notice of that claim?
Yes, Your Honor, because the asset purchase agreement expressly states that if you want to bring a claim for a default, there are conditions precedent, and those conditions precedent were not pleaded in the operative complaint. There was no showing in support of the plaintiff's motion for summary judgment that they had made those predicate complaints. They had asserted a demand. And notably, the record is devoid of any indication that they properly asserted pursuant to the asset purchase agreement, a claim for indemnification, a claim for breach of contract. But what is clear is that if we look at the document that they are now referencing as part of the improper recasting of this specific performance claim, to address Your Honor's question earlier, they are asserting that there was a breach of contract of the assignment agreement with the landlord because the landlord failed to return a security deposit.
Yeah, based on your client's undisputed, that is, to comply and pay rent, additional rent, correct?
It is disputed, Your Honor.
Oh, it is disputed?
It is disputed, and that's why we cross-moved for summary judgment, because while they failed to allege...
Are you saying that your client paid rent during the...
During 2020.
It's, respectfully, Your Honor, that's not the issue. The issue with the deposit is whether my client participated in obtaining a temporary certificate of occupancy. It's undisputed that they did participate in that the TCO was obtained, and that was the condition for the landlord returning the money.
No, isn't the landlord claiming that it's not returning the money because you didn't pay the rent?
They may claim that, Your Honor, but that's a
And don't you have
fight.
an obligation under the assignment agreement to keep the tenancy in good standing even after the closing and even after 2018?
And Your Honor, that's...
So is that a yes?
No, Your Honor.
You don't have any obligation to keep that tenancy in good standing while the landlord's holding the assignor's $250,000? There's no obligation under the REIT?
I thought that that's precisely what the APA's language is in sections 1.2 and 8.2.
Your Honor, if I could just answer that briefly beyond my time. So that is exactly why summary judgment is inappropriate here. That's a material, factual dispute that would preclude granting summary judgment.
If we read the documents and we think that's true, then that we don't think there's any ambiguity, then wouldn't that be proper for summary judgment?
No, Your Honor, because the summary judgment was awarded on a claim for specific performance of the APA, but the APA had expired. What Your Honor is referencing is the assignment, which had not expired. They're two separate documents, one of which the plaintiff is not in privity with the landlord with, and they can't assert any breach of contract or specific performance claims under. And for those reasons, the trial court...
Well, the section 5 of the assignment contract also required TSI to keep the tenancy in good standing, even after closing.
And Your Honor, there was if I may, again, beyond my time.
Go ahead. No, don't worry about the red light. That's for you, not for us.
Thank you. And basically, there's a mechanism outlined for asserting a breach of contract claim. They didn't comply with it. They can't prove any prima facie case for summary judgment under a specific performance claim. This court ruled last year that you can't have basically a creep, a reframing of your causes of action during the course of a litigation. It's improper. It deprives my client of notice and the ability to basically properly frame and dispute elements of that claim. That's exactly what they did here. They have a boilerplate and improperly vague specific performance claim related to the APA when it's apparent that there was a breach of contract claim against the landlord who they settled with. They cast the course of this litigation by settling with the landlord and then bringing an improper claim under an agreement that had terminated against...
Okay. Got it.
If there are no further questions.
I think we're good. You get a minute on rebuttal.
Thank you, Your Honors.
May it please the court, good afternoon. Thomas Shanahan of Thomas D. Shanahan, PC.
So counsel, is your adversary correct that in fact that you never asserted some kind of claim under the assignment agreement?
Of the assignment being in default, Judge?
Right.
In my brief on page, I think it's 6, I actually have a colloquy from the record in front of Judge Ngoran. The attorney speaking at that time was Mr. Clayman, who's now passed away. He was representing S.L. Green, who was our landlord. When we obtained the TCO, we immediately presented that to S.L. Green. They then notified us of the default that had happened in the lease. It was $1.2 million in rent that had not been paid. We sent a notice of default immediately to the appellants, putting them on notice of this. And this is addressed by Mr. Clayman, saying we received the notice of default, but we're making our demand for $1.2 million insecure in rent that's owed.
So it was over $1 million in arrears by the time that they procure the temporary certificate of occupancy.
That's correct, $1.2 million. So the landlord was functioning as really an escrow agent for purposes of that $250,000 that came from the sale of the business. The landlord was obligated to hold that money in escrow. My client was obligated to work with the city to get the TCO issued. And the appellants were obligated to pay the rent and to keep the lease in good standing.
So that's what the documents say, but really what your adversary is making is a notice argument, that you made a claim for specific performance. We weren't on notice of your breach of assignment claim, and that's what I'm trying to get at. Were they on notice in the pleadings themselves?
Well, prior to the pleadings being filed.
In the pleadings, did you make any claim about that?
In the pleadings itself? Yes, we in our moving papers, when we filed in the court below, in support of 2 orders to show cause that were filed, we had the notice of default in the lease. If you like, I can look in the record and just point that to you. That was sent to the appellants prior to the commencement of the action, saying, you now must cure this default of $1.2 million. We served it in New York, we served it in Florida, at every one of their corporate offices. They ignored it. We then, after meeting our contractual obligations to provide them with notice of default, we then we filed the pleadings, and then we moved for interim relief. And we were granted a TRO, by Judge Bluth. So as far as this privity argument or the notice arguments, they received notice as required prior to commencement. At the time, when I spoke to counsel, it was not Mr. Chester, but Mr. D'Angelo. They said, look, it's the pandemic. Yeah, we owe the money, but that's just too bad. Well, I would say this, if we had said to them, well, the pandemic and the TCO costs money, so we're not going to go get the TCO, I might be the appellant in this case, and they may be the respondent, because they would have brought an action against my client for breaching this obligation. The obligations are clear. The record is clear. They survived closing on the asset purchase agreement. We had obligations, they had obligations. We met ours, they didn't meet theirs. Judge Ngoran got it right twice, and I would ask that this court affirm the decision of the court below, and thank you.
Okay, thank you, counsel. Okay, I'll give you the extra 15 seconds.
Thank you, Your Honors. I think just very briefly in reply here, it's clear that there are multiple material factual issues raised regarding who told what whom. I suspect that some of those are absolutely outside of the record. What is clear from the record is that the operative complaint pled a specific performance claim related to an assignment of lease.
You received the notice of default. Would that put you on notice of what the actual claim was?
Only if that purported notice, Your Honor, actually complied with the notice requirements of the APA. The complaint is devoid of anything related to this whatsoever. For that reason, they cannot meet the burden.
No, if Section 5 of the assignment contract and Sections 1.2 and 8.2 of the APA require you to keep the tenancy in good standing, and after they commence their action, they serve you with notice that you owe us $1.2 million. You have to, clearly you're in violation of the requirements of those sections, right?
Your Honor, there's a dispute over whether rent was owed to the landlord or not, but that's extraneous from the fact that the landlord...
What's the dispute? They have a notice of default that got served on you. Is there any document saying, oh, no, we were not required to pay that money because section whatever of the APA says we don't have to pay it? Is there anything at all other than the pandemic?
Absolutely, Your Honor. What we're talking about here is TCO money to get a TCO. It is not disputed that this building got a TCO and that that is the sole condition precedent for returning the TCO money to the plaintiff. This is a separate fight that they have, and
So
my
essentially what you're saying is it's not your problem, that's with the landlord, the $250,000 has nothing to do with you. I mean, that's essentially what you're telling me, right?
And if they wanted to make that our problem, Your Honor, there's a specific procedure that was not followed based on the documents in the record.
Okay, thank you. Thank you both.
Thank you very much.
Immigrant Bank?
May it please the court, Gary Gans on behalf of appellants and plaintiffs. Interestingly, this case has two issues, both involving standing. The threshold issue is Virgo's standing to enforce the terms of the credit agreement. Virgo has abandoned the argument they made below.
Can you start with the what happened in bankruptcy court? I understand it's outside the record, but did bankruptcy court issue an order in this case?
Yes.
And what was that order they issued?
The bankruptcy court did not enjoin this action, did not find a violation of the automatic stay. So we are good to go.
So there's no bar order, is that right?
Correct.
Okay.
The bankruptcy court, just for completeness, did say we cannot bring alter ego claims against Virgo, but we are not doing that.
So wasn't that the linchpin of the decision below? Wasn't that the whole basis for the decision that these have to be alter ego claims, that the only way these claims could possibly be brought is on a theory of alter ego, otherwise there's no basis for bringing these claims?
No, the alter ego allegation is only to provide that Virgo had access to the financial information.
But otherwise, you're a stranger to these agreements.
Yeah, right.
You are a stranger. How can there be any basis for any claim when they're not parties to the agreements?
Virgo made direct representations to my clients.
But Virgo is a non-party to the guarantee agreement, right?
Correct.
So they basically call Recien's alter ego.
Well, there's the guarantee agreement and then there's the credit agreement.
Right.
Your Honor is referring to the guarantee agreement?
Yeah.
Okay. Yes, we are alleging that Virgo is the alter ego of Calrissian. And as the alter...
And counsel, let me just interrupt you. And didn't the bankruptcy court just say you can't make that argument?
No. No.
Wait a second. Did the bankruptcy court not say plaintiffs violated the automatic stay by bringing this action and that they were not permitted to pursue causes of action based on a theory that any of the defendants was an alter ego? Is that not what the bankruptcy court said? Do you have a copy of the bankruptcy court order?
I do not, but we can supply it to the court.
Yeah, would you do that for us?
Yes, and there's a distinction between Calrissian and the debtor in the bankruptcy is Alchemy. So those are two different issues.
Well, they were both in bankruptcy, though, and therefore unreachable.
Calrissian came out of bankruptcy. They were at one time in bankruptcy, yes.
And these claims were in that bankruptcy proceeding. These claims post-date that bankruptcy?
No, but they were not in the bankruptcy.
No, I'm saying that they would have been encompassed by that bankruptcy proceeding, correct?
No.
Did they post-date the bankruptcy?
No.
Did they predate the bankruptcy?
They did predate the bankruptcy.
So then how come they're not encompassed by the bankruptcy proceeding?
Because there is no claim of a theory of based on a theory of alter ego liability between Virgo and Alchemy. There is no such claim. There's only a factual claim that they were alter egos, so they had access to financial information. And that's what the bankruptcy court
So then what is your claim? How can you claim damages if they made if a non-party if the governor of New York makes a false statement to me that has nothing to do with a contract that I have with someone else, how could that be actionable unless they're alter egos of each other? What is your theory then?
Well,
Why is it actionable as to you?
One theory is that they misrepresented the assets of Calrissian. That has nothing to do with the Alchemy bankruptcy. And what the bankruptcy court specifically said at the hearing was that these are direct claims against Virgo, that Virgo made misrepresentations. They are not based on an alter ego theory of liability, and therefore they do not belong to the trustee, and there was no violation of the automatic stay.
Okay.
So he said
you're
we're good to go.
saying with respect to,
I mean, while you look,
I don't even have that party as a defendant here.
yeah, All Alchemy is not a defendant, and Corician, they're both in bankruptcy,
here. So,
and they are unreachable. So you decided that you had a colorable claim against Virgo, who's a non-party to the guarantee agreement. And the only way you do that is as Calrissian's alter ego.
Correct.
Why are you saying Virgo did something directly, although they're not a part? Explain the theory to me.
Sure. We have to separate Alchemy and Calrissian.
Okay.
Calrissian is out of bankruptcy. There has never been any allegation that our alter ego claim against Virgo, based on its alter ego relationship with Calrissian, violated the automatic stay or that we could not proceed with that. That's never been
But your
alleged.
underlying theory is about the inability of Old Alchemy to pay the credit agreements. And that's the inherent gravamen of your claims, that misrepresentations were made about the ability to pay this claim in the first instance, the debtor's inability to pay the claim, not Calrissian's inability to pay, to honor its guarantee. So I don't know how it doesn't go back to Old Alchemy, who is the debtor.
Our claim is not that Virgo is responsible for Alchemy's failure to pay under the loan. Our claim is that Virgo made direct misrepresentations, some involving...
but I guess, again, so what? That's our whole point. The only way it becomes a so what is if through the alter ego theory. If somebody who's a stranger tells me tomorrow to go and buy stock that died yesterday, I don't have a claim against that person unless there's a connection. If it's just, that I think is what we're all struggling with.
The difference is that somebody can have knowledge of whether it's Calrissian's financials or Alchemy's financials without being an alter ego.
But what duty do they have to you? What duty to tell you the truth do they have unless they're an altered ego? They don't have any duty to tell you the truth. I can say whatever I want, wherever I want, whenever I want. The only time it's actionable is if I have a duty to tell you the truth. And so where is the duty?
Virgo has a duty when it makes representations on which the lenders relied.
Why? Why do they have a duty to you? Under what theory do they have a duty to you to make, they're not your...
They're not a party to the agreement.
Why is it reasonable for the plaintiffs to rely on anything Virgo says when Virgo's a non-party to
the guarantee
any of the
agreement?
guarantee or the underlying obligation? Why do they have an obligation to tell you the truth?
Well, that goes right to the heart of what the bankruptcy court held. The bankruptcy court was aware that we alleged that Virgo had knowledge of Alchemy's financials as its alter ego. But the bankruptcy court was very clear that is different than alleging an alter ego.
Okay, but still, you're not explaining to me why they have a duty to tell you the truth. Why is it you weren't their client? You're saying they're not the alter ego of the party who did have a duty to tell you the truth. Under what theory are you saying that they breached a duty to you? What duty is it for a stranger to tell you the truth?
Sure, when a stranger, whoever it is, has superior knowledge of the financials of another company, superior knowledge, they have a duty to tell the truth. That is the
Where,
law.
where does
But
that
what's
come
the
from?
private right of action that you have? I mean, I can see the SEC or whatever governmental compliance agency will say, you know, you can't lie in your filings and et cetera, but what is that to you?
Well, what it is to us is that induced us to enter into an agreement for the benefit of Virgo.
So you're saying if Merrill Lynch put out a bulletin and saying, we looked at this company's financial information and boy, does it look good, and then you bought stock and your stock tanked, that because Merrill Lynch, just because they had more information than you, had a duty to tell you the truth and that you could sue them for material misrepresentation?
Well, that you can justifiably rely, right?
Well, there's a distinction between opinion and facts. And what we're dealing with here are facts.
I just don't, you tell me a case where that, a non-party to the agreement has an obligation to tell the truth to you and that you can sue on it in a private cause of action.
I would be happy to provide that in a letter to the court. I don't
Okay.
have it offhand.
So on the issue, your time ran out, so maybe you wanna, because I'm gonna be asking questions of the other side on this. I heard your argument in your reply brief with respect to Bill Bank not controlling. I think differently, so tell me why, and that's assuming you get past the issue of standing, right?
Right.
On the merits, why is Bill not controlling?
On the standing issue? I'm sorry, Your Honor.
No, on the merits, I mean, no, I'm sorry, on the merits of.
Why in the face of an agreement that says only this party can bring a lawsuit, do you get to bring this lawsuit? I think that's what you're saying, right?
Yeah.
Okay, because that's not what the credit agreement says. What the credit agreement says in section 9.13 is that only the administrative agent can bring lawsuits on the collateral documents. This is not a lawsuit on the collateral documents. So that's why. Number two, in Beal, 36 of 37 lenders said don't sue. And Beal said it's the will of the majority, the required majority that counts. It's not the action of the administrative agent. Beal involved only a contract action, which is a key distinction, because the defendant there was obligated under the contract and raised a contract defense. And in Beal, there was no reference to any section 9.13 or something like that, which gives exclusive authority to the administrative agent. And if I could just make one other point in terms of the previous discussion, there are causes of action to this complaint other than fraud. So even if ultimately it turns out that we were not justifiable in relying on these representations, we have causes of action for unjust enrichment. We have causes of action for interference with contract. We have a cause of action for aiding and abetting fraud. None of those causes of action are impacted by Virgo's duty or lack of a duty to disclose to us. Thank you.
Talk.
Thank you, Your Honor. May it please the Court, Emmanuel Grillo, Allen, and Overy, on behalf of the defendant, respondents, otherwise known as the Virgo parties. So,
Can I just ask you, do you
Yes.
agree that the bankruptcy court has not stayed this action?
the bankruptcy court, I agree, the bankruptcy court has not stayed this action.
Oh, it hasn't. It hasn't said that this is not an appropriate action.
Well, no, the bankruptcy court didn't exercise any judgment with respect to the propriety of the action itself. What the bankruptcy court said is that what they are not allowed to do, which is replete in their complaint, is make claims based on alter ego
We
allegations.
have to make that determination. If we decide that for them to have viable claims, they have to be based on an alter ego theory, then the bar order prevents this action from occurring.
That is
And
correct.
if we find the opposite, that they're not alter ego claims, then the bar order does not prohibit it. And
That would
that's
be-
what we have to figure out.
I agree with that, Your Honor.
Now, your adversary argues that there are claims here that aren't predicated on alter ego, unjust enrichment, for example. Is that correct? I mean, are all the claims, I know that the complaint is replete with that term, but are all the causes of action predicated upon alter ego, or is there a separation between the two?
They are all predicated on alter ego. And those claims that one might argue are not predicated on alter
Well,
ego.
unjust enrichment. How would unjust enrichment, for example, be predicated on alter ego?
The unjust enrichment claim says basically that the Virgo parties benefited, and what those claims effectively do is they attack the same claims that were brought in the bankruptcy court under fraudulent transfer theories by the Chapter 7 trustee. So essentially, those claims, i.e. the unjust enrichment claims, are duplicative of what the bankruptcy court addressed and settled with respect to monies that they allege that Virgo took out of the company, all of which was the subject of the Chapter 7 trustees' action against all of the Virgo parties that was
So we
settled.
didn't have the bar order in place, obviously, when the trial court made its decision. But is your argument that the trial court did hold that all of the claims in this action are based on alter ego?
The trial court admittedly did, well, in its decision, the pure confines of the trial court's decision
Which
is
was a
that,
standing issue, I understand. It
Yes.
wasn't about the bar order.
yes, I'm sorry, Your Honor, I missed the last part of that.
It was not about the bar order because the
That's
bar
correct.
order had not been issued yet. But in the confines of the standing, what is your understanding of what the trial court held about the issue of piercing the corporate veil and alter ego?
Well, there was, if you look at the transcript, which is part of the record from the hearing, the colloquy there very much mirrored the colloquy that just went on here, which is the issues around duty and everything else. And just to correct what was put into the record about what the alter ego allegations are specifically, and this is replete throughout the course of the complaint, counsel, I believe, said that, well, the alter ego allegation was only with respect to Calrissian, with respect to the guarantee. That is not correct from their own papers. Paragraph 34, if I may, says, furthermore, at all times relevant hereto, Calrissian and Alchemy acted as Virgo's alter egos. Virgo owned and exercised complete dominion and control over Calrissian and Alchemy to perpetrate fraud and other wrongdoings against the plaintiffs. Virgo's misuse of the legal forms and shifting of assets from Calrissian Alchemy to Virgo was designed to enrich Virgo and its principals while shielding Virgo from liability to the plaintiffs. So, to Your Honor's point from before, all of these things are wrapped together. And if you look in the complaint, there's at least 7 or 8 other references in the complaint connected to each cause of action where the alter ego is a principal element of that claim. What the bankruptcy court said is, hey, no, you can't do that. You can't base your claims because those claims were before the bankruptcy court and were settled as part of that proceeding. The irony here is that, if that were the only lawsuit involving these parties and the demise of Alchemy, but the bottom line is we are now on 4 lawsuits altogether, and I think it's important to take note of all of them. Specifically, with respect to the bankruptcy case, in addition to that, SunTrust, as the administrative agent, commenced an action against Calrissian as a guarantor and against Virgo Services Company, one of the defendants in the underlying action. And this is what points out the BO problems that come before this court, and I'll get to that in a moment. The third is the lawsuit commenced by the plaintiff appellants, Emigrant and PMB, against SunTrust for breach of the same provisions of the loan agreement, which they now disavow and attempt to unrun in their pleadings today. The lawsuit in which that they failed to disclose in the trial court, which we brought to the court's attention as a remarkable lack of candor. The bottom line is that the same provisions that they tell this court and that they told the trial court did not apply in that federal court action, they say is plain and unambiguous. Section 8.1, there is no dispute. And one more point on that. When you look at the claims—
Wait, so are you saying that these claims are covered by the federal lawsuit?
These claims are covered to the extent that they assert liability against SunTrust for failing to bring these claims. In other words, they say they breached the agreement for failing to bring exactly the same alter ego claims that are here. I realize my time is up, but I have just one more point that I would like to make in that regard.
So, could you address the standing issue? Because that, your adversary says that we shouldn't follow Beal in this case. What's your position on that?
And that was the point I was going to make, so thank you very much for the opportunity. Very simply, 8.1 and 9.1 of the credit agreement here mirror almost exactly what are 8.3 and 9.1 in Beal. These provisions are exactly on point, meaning that their clients gave and delegated irrevocably the right to bring any claims and causes of action without qualification as to type, without qualification as to timing, and without qualification as to title as to who owns them. Their papers go through 42 other irrelevant provisions of the agreement, and even raised one today, section 9.13, as if to say that, oh, well, that's the only place where it's exclusive. If you look at their papers, they exactly mirror what the dissent said in the Court of Appeals decision. All of the shortcomings that the dissent raised that were overruled by the majority in that opinion are basically the foundation of their complaint.
Does it matter that they have a majority of the lenders rather than a minority in Beal?
Well,
they make a lot out of that.
They do, and they're right to do so because that's the crux of their claim in the federal court action. The bottom line is that, and that's where the authority is, and that's why they don't get the right to bring the claims, because in theory, under the credit agreement, they should be permitted to tell the agent what to do. The agent didn't do it, the agent didn't refuse, and a year and a half before they...
Well, SunTrust, in fairness, SunTrust sued Calrissian, right?
Yes, they did.
On behalf of some of the lenders.
And they not only sued Calrissian, but they also sued Virgo Services Company, which is one of the defendants in the action here. And this is why credit agreements are designed the way they are, because now Virgo Services Company is the subject of a lawsuit from the agent. It's a subject of this lawsuit here. And that's exactly why when Beal came out, and Beal was in place from 2007, so it's not like they didn't know about it. What the court in Beal says is if you want to qualify something, it's your obligation and your duty to do so as a party to the agreement.
Right. Okay.
Thank you all.
Thank you.
There are a number of issues that I need to correct the record on. First of all, that the other causes of action are not predicated on alter ego. The unjust enrichment claim is basically fraudulent transfers from Alchemy to Virgo. It has nothing to do with alter ego. Interference with contract, aiding and abetting fraud, they have nothing to do with alter ego. And the bankruptcy court was very clear to distinguish between an allegation of alter ego for purposes of knowledge of financials and alter ego theories of life.
Let me ask you this. Did you take the position in the federal court that SunTrust was required to bring these claims once you made the demand?
Absolutely not.
You didn't?
Absolutely not.
What did you say in the federal court? Why would you have sued them?
In federal court, and this is key because this involves half of what counsel argued. In federal court, we sued SunTrust for failing to sue Virgo as the alter ego of Calrissian for breach of the guarantee. And why that is critical is because section 9.13 of the credit agreement says that the administrative agent has exclusive authority as to the collateral documents. That's it. That's the scope of their exclusive authority. And that's why we sued SunTrust in federal court, because the guarantee is a collateral document.
That's the only thing you sued them for failing to bring?
Yes.
You didn't bring any other, you didn't say any of this they failed to bring?
Correct. That's absolutely correct.
No, there were, okay, I think your adversary's saying something different, so we'll have to figure that out.
Yes, they were, and they said it repeatedly to the Supreme Court, who adopted that, and it's absolutely wrong. Flat wrong, not even arguable. All we have to do is look at the allegations. Absolutely wrong. Unjust enrichment, was not barred by the bankruptcy court. The bankruptcy court said nothing about that or the other causes of action. Nothing. Now, the 9.13, they continue to give absolutely no meaning to. They rely on 8.1, which says nothing about plaintiff standing or the exclusivity of SunTrust's authority. 9.13 does address both of those. And what it says is no lender has a right individually to enforce the collateral documents, and all remedies under the credit agreement and the collateral documents may be exercised only by the administrative agent. And what that means, clearly, is that any other claim, such as our tort claims and unjust enrichment and all that, are not within the exclusive authority of SunTrust. And
So, but if we disagree with you and we find that Beal is applicable, these claims go out on standing grounds, even the unjust enrichment and all the other claims, correct?
no, and let me read.
I mean, assuming, I hear what you're saying. This isn't the SunTrust doesn't have the exclusive authority, but if SunTrust does, then you don't have standing, correct?
No, and let me explain why. In the appellate division opinion, as, in Beal, it says that
So, I'm just, if we assume that Beal says what it says, and we agree that it applies here, you're still saying that you, under what theory could you bring a claim if you don't have, if we find that SunTrust is the only one that could have brought the claims?
Beal expressly deals only with a contract cause of action.
Again, assuming, okay, great, thank you.
I'm sorry, if that doesn't answer the question, then...
Good, thank you.
Okay.
No, the question is really whether Beal controls and what the Court of Appeals characterizes unequivocal collective design basically precludes you from, as a lender, from suing individually. There's a reason why this scheme was created.
There's 3 points on that. First, what Beal said is the collective design is that the required lenders, the majority or the supermajority in that case, control. That's not what we have here because the required lenders here opted to sue. In Beal, 36 out of 37 said don't sue. That's one. Number two.
I don't think that that's even relevant at the core of Beal, whether you have a majority or a minority. The fact is that that is the unequivocal collective design that you came up with. If you wanted to preserve the right to sue individually, you would have done so.
Well, that's what
should have done so.
That's what 9.13 does. And 9.13, there's nothing like that that's referenced in Beal. And in fact, Virgo makes that point inadvertently in their brief. They say, quote, in the absence of an express prohibition on an action by an individual lender in that case, the Court of Appeals looked at other specific clauses and the agreement as a whole to ascertain the parties' intent. Here there is such an express provision. It's 9.13, which they and the Supreme Court give no meaning to. You have to give some meaning to 9.13. And the fact that it says that they have exclusive authority as to actions to enforce the collateral documents shows that they do not have exclusive authority as to other actions like we have here.
Okay. Thank you, counsel. Thank you both. Great arguments.
Thank you.
Silo versus City of New York. Okay, so you came in.
If it please the court, Ray Koshetz for Timothy Silo. I have three fairly simple points to make on this case, and I'm sure that I've seen that how well prepared this court is with facts on these matters. First of all, the verdict in this case was against the weight of the evidence. The evidence here was overwhelming that Timothy Silo...
Just in terms of the what you're going to characterize as overwhelming evidence, wasn't there non-discriminatory reasons that were set forth? His unprofessional behavior from the incident at the club, how he failed to respond to a sergeant, the fact that he had these 2 substantiated complaints during his probationary period. Why isn't that a fair interpretation of the evidence that led to the verdict?
Well, for one thing, Your Honor, the jury was unable to hear that the city had consistently and unequivocally argued all through the pretrial proceedings, right up to opening statement, that Timothy Silo was fired because he was an alcoholic, he was untreated, and therefore unable to invoke any discrimination.
Counsel, you're really referring to the summary judgment motion, correct? That's where they espouse that theory, correct? On the summary judgment motion.
I'm sorry, I didn't understand.
Let me take my mask off. When you make that argument, you're referring to the summary judgment motion, correct?
That's right.
So why are they bound, if they didn't move on summary judgment on claims or defenses that they may have, why are they bound by that summary judgment determination? Why can't they raise that at trial?
They could raise that at trial, except that what they did was a complete turnaround, Your Honor.
Wasn't there a letter from the chief of personnel which also expressed other reasons besides the alcohol dependency for again, that would go into the weight of the evidence. So it's not a new theory. It's something that they had expressed before. It's just that in their summary judgment motion, they pursued one avenue.
I would submit to you that it's pretty clear from the firing memorandum, which was really the key document in this case, that he was fired because they determined that he was going to be an alcoholic. And the key language is at the end of that memorandum, which is page 413 of the record. And that says in sum and substance, I'm not going to quote it this late in the day, it says that Dr. Scanlon, who was the alcohol counselor, determined that he would have alcohol problems in the future. We agree.
But that was only part of the evidence, right? The other evidence in the record, for at least for the termination, cites to the unprofessional behavior during that off-duty incident that Justice Pitt mentioned. It talks about his dishonesty, evasiveness, failure to take accountability during subsequent interviews about that incident.
I'm delighted to address that, Your Honor.
Okay.
We have in this case, and certainly fortunately for the appellant, 3 similarly situated officers.
Are they similarly situated? Some of them did not have the substantiated complaints against them. Some of them took a responsibility immediately. So they're not necessarily similarly situated. I think the cumulative evidence that was presented that was non-discriminatory, didn't rely on alcohol, distinguishes him from the other officers.
May I respond?
Sure.
Well, first of all, the disciplinary records of those 3 officers were disclosed. However, no interviews of them were done. There was no alcohol evaluation done of those other 3 officers.
So could I ask you a question about that?
Sure.
At the club, isn't it correct that it was only your client that showed his badge? The other officers did not show their badge, correct?
I'm happy to
And
address
well,
that.
that's just a yes or no?
He showed his badge,
Okay,
yes.
so is that a distinction between the actions of the other officers not showing badges and what your officer did in an attempt to get into the club?
If you look at this holistically, absolutely not. He did not show his badge in order to achieve any kind of benefit for himself. It isn't like the cop who goes to the movie theater and...
Well, he wanted it, he showed the badge, so in order to get entry to the club, right?
He wanted to get his friends out. Remember, he was not drinking inside that bar, and he had...
But he had drunk before, though.
Way earlier in the evening when they were all drinking at the precinct Christmas party.
Okay.
My client, there's no proof my client was drinking after that at all.
Just with respect to the, and I know your time run out, but I wanted, because I know the city is going to talk about why your client is not similarly situated to the other three individuals that you mentioned. And one of the ways is that your client had received 4 civilian complaints, including 2 that had been substantiated. You want to address that?
One that was substantiated was for a stop and frisk at a time when that was, for better or worse, it was city policy. He was a probationary officer, and there was no punishment given out to him for that.
There was another one about improper use of a baton, right?
That was not adjudicated. That had been put, that was only a complaint. It had been put on hold when he received this punishment.
Okay.
The other officers, one other officer, at least one other, had been on one of these lists of officers who have civilian complaints, yet the court below refused to allow that in evidence. He only allowed that document to be made part of the record for this trial.
I'm sorry, you're saying the incident with the unjustified use of a nightstick was not substantiated? Wasn't he placed on restricted and modified duty for that?
Oh, the use of the baton, let me be clear. Evidently, the Civilian Complaint Review Board substantiated it. However, there had been no adjudication of that.
But he was placed on modified and restricted duty because of it, so there was some kind of penalty from the department itself.
Not necessarily. Those
Okay.
lists are based on complaints. Complaints alone. If you have a certain number of complaints, your career is placed on hold. So at least one other officer had been on one of those lists.
Okay.
Mr. Sila was not the only person who had civilian complaints at all or had been on a list, and not any of the other guys had an alcohol evaluation. We called all 3 of them to the stand at this trial, and there was this mysterious, sudden epidemic that occurred. Not a single one of them could remember how much he had had to drink that night. One of them said, oh, I think it was maybe 1 beer. I don't know if I finished it or not. They were in a bar. They were drinking. Tim Silo was the adult who tried to get them out, and he wasn't drinking. What's critical here is to have an alcohol counselor saying, well, if his father was an alcoholic, there's a good chance that if one member of your family is alcoholic, another person will be alcoholic. And I hope you will agree with us that that is extremely scary.
Thank you,
to face a
Counsel.
decision on that.
Thank you.
Good afternoon, and may it please the court. Chloe Moon on behalf of the respondents, City of New York, and Raymond Kelly.
So, counsel, what other evidence was presented besides the alcohol dependency at trial?
Yes, absolutely. As the firing termination recommendation makes clear, there was a credibility concern with the plaintiff. These evaluations were showing that he had a lack of integrity, a lack of candor with all these evaluations. But on top of that, it also shows that the IAB investigation that was substantiated for 3 different things: engaging in a physical altercation, failing to remain at the scene, failing to notify IAB. He also had these CCRB complaints against him, 2 of which were substantiated.
He called 911 and did not identify himself?
Exactly, Your Honor. And he showed his badge to get into the bar. And
But what your adversary is saying, that's not correct. He was actually trying to save the officers by going into the bar to rescue him, and that's why he showed the badge. Is there any evidence of that?
I think ultimately that's a distinction without a difference here, because he's trying, even assuming plaintiff's version, that he's trying to go in to get his friends.
And did the jury hear that
evidence? Yes, absolutely, Your Honor. And ultimately, that brings me back to the primary point here, which is that the jury had a valid line of reasoning here to determine that the plaintiff was not terminated for unlawful reasons. There were ample, non-discriminatory, legitimate reasons that could have been the motivating factor here, and that evidence was all on display in front of the jury, including plaintiff's own testimony, the testimony of these comparators that plaintiff's counsel is discussing. All of that was in front of the jury, and the jury was instructed on motivating factor defenses. So it was aware that if it had found that alcohol dependency was a motivating factor, that would be unlawful. It knew that, and it decided, the jury decided, that there were valid lines.
Was the chief of personnel's recommendation for termination presented to the jury or introduced as evidence?
I believe so, yes. I believe that was Defense Exhibit A included that, yes. Okay. So all that language was in front of the jury.
So the other argument is that the city is taking inconsistent positions here, and you should be judicially stopped. How do you respond to that?
Yes, Your Honor. Ultimately, a position on summary judgment is not the same position that you have to take when you're at trial. A position on summary judgment, for example, would assume all the facts and evidence in favor of plaintiff, and that's what's happening here. Once you get to trial, any legitimate non-discriminatory reasons are the ones that you're supposed to present, that you're allowed to present. And so that's where that...
And had you asserted those defenses in your answer with respect to that there are other legitimate reasons?
Absolutely, Your Honor. And even in the summary judgment motion, we cited to the termination recommendation, which includes these other reasons. So there was ample evidence that it was consistent throughout. But even assuming it was a different position, that summary judgment position just doesn't have to be the same, exactly the same as what we're arguing at trial. And for these reasons, we ask this court to affirm.
Okay, thank you.
Thank you so much.
The firing memorandum wasn't about civilian complaints at all. The city's defense to this lawsuit was the man is an alcoholic. He's an untreated alcoholic.
I'm sorry.
No, but actually, no, the memo, and this is why I asked whether the chief of personnel's recommendation for termination was part of the record before the jury. It was an exhibit before the jury. That is the same, memorandum that talks about Dr. Scanlon's evaluation, which you expressed concern with, but it also contains Dr. Scanlon's conclusion that plaintiff or petitioner in this case was defensive, evasive, and deceptive. He said that it was difficult to get reasonable answers from him to very basic questions, particularly those involving alcohol. Dr. Scanlon also found that your client was not credible and was at risk of future alcohol-related problems. So I know that I see you look skeptical about just because alcohol is mentioned doesn't mean that that was the sole basis for which the decision was made.
I don't think that we had to prove that. We have to
No,
prove
you
that it
don't.
was
You
a
have to introduce-
significant factor in his termination, Your Honor.
But that's for the jury to evaluate, and the jury evaluated it. Was he fired for an impermissible reason, or was he fired for these non-discriminatory reasons that were proffered by the, chief of personnel and other evidence in the trial? This is a post-trial decision.
May I mention two things?
Sure.
Suppose that when the city comes and for the first time an opening statement says, this is not a case about discrimination, ladies and gentlemen. This is a case about a bad apple, a bad news bear, a horrible person, and they do that all through the trial, and we immediately object, and the judge will not take any action. Suppose the jury had been able to hear that they had argued all along that he was an alcoholic. Would that not have changed the result? Secondly, we haven't talked about the conduct of corporation counsel in this case, which was nothing short of outrageous. What they did...
But that conduct has to be evaluated in the context of that Minichiello case, right? So was trial counsel's conduct or misconduct, as you claim, so violative of your client's rights that extraneous matters beyond the proper scope of the trial may have substantially influenced, substantial being the key word, right? Or inflamed the jury's passion and sympathy to the extent that the resulting judgment was meaningless.
Absolutely.
Okay.
We would have called Juanita Holmes, 3-star chief in the NYPD.
But she was
had
not,
agreed-
she was no longer in the department. You tried to get her.
She was the subject of a subpoena that had been lawfully served on her, a court-ordered subpoena. Now,
They gave you her number, didn't they? And you tried to, you meaning counsel for Mr. Silo.
talk
And
to
you
her.
tried to talk to her. She
Talk
told
to
you she
her.
was going to be out of the
No,
state
we talked
for
to
some
her and
time.
she said, delighted to come. I will absolutely come and testify. Not only that, but we were assured that she was going to come and she was going to counter.
Had she been deposed prior to the request for her to come in at trial? Had she been deposed? Was there a request to take her deposition or some way to preserve her testimony?
There was, but why should a fired police officer have to pay to depose a high-level city official who was under court-ordered subpoena, who had agreed to testify, was well aware of it? I mean, is that the
But legally-
responsibility of our...
But legally, but it's not their responsibility under the law. They have to have control over that individual. She's no longer employed by the department.
Judge, they exercised control over every witness. In fact, the corporation counsel lawyer said to me, nobody shows up at this trial unless I tell them to. Not only that, but they were representing her all the way through. On the Tuesday, when she was to testify, I spoke to corporation counsel, and this is sworn in an affirmation. And I asked the young lawyer for corporation counsel, I said, did you know that she was not going to appear? And he said, I spoke to her on Saturday. I said, what did you tell her on Saturday?
We read that in the record, counsel. So thank you so much. Your time has run out.
Thank you for
Thank you
hearing me.
both. Lambro versus New York City DA's office.
That shot is not a great idea.
Yeah, I keep testing negative, so it's nothing. It's just a bad call. Yeah, my little grandchild has it. It's like a bad chess call. It just keeps coming and going. Yeah.
Good afternoon, Your Honors. May it please the Court. My name is Corey Morris, and I have the honor of representing Lambros Lambrou. In this matter, this freedom of information law matter where we seek transparency and accountability, we seek reversal, a declaration that the respondents
So your claim, counsel, was a constructive denial, am I correct?
The claim is a denial. It's a
It was not a constructive denial?
It was a substantive denial, Your Honor. It was a denial that came after an appeal, and this Court requires us to act timely after that appeal is made. So the respondents argue that, and in fact, they characterize this throughout their papers.
Counsel, didn't you have to amend your petition or bring a new petition if you wanted to challenge the actual denial versus the constructive denial, which was the basis of your initial petition?
Your Honor, we didn't have to amend the petition, and for that, also for that matter.
How did it become part of, if the original proceeding was based on a constructive denial, how did the actual denial become part of the proceeding if you never amended your petition and you never brought a new petition challenging the actual denial as opposed to, or partial denial as opposed to the constructive denial?
Your Honor, we appealed, and that was the final determination, and that's this Court's decision, actually. Jewish Press versus New York City Department of Housing and Preservation. That's 193 83rd.
So we get to address your claim, your challenge to the claim exceptions that were made, although they're not part of your petition?
It should be remanded at best, Your Honor. That should be part of this. Just to be clear, Your Honors,
How can it be before a trial court if it's never been in a petition? If you've never brought a proceeding to challenge the denial, how can it be before any court? How could it be the subject of this appeal?
Again, Your Honors, this was challenged. The underlying request was challenged, the denial, the constructive denial. There was an appeal, and that denial was
so now, I'm sorry, go ahead.
There's different standards for how we assess a constructive denial versus an actual denial. There's completely different standards. There's different standards for whether or not to award attorney's fees. So I don't understand how you're arguing your constructive denial appeal brings up anything to do with the actual denial.
Your Honors, I want you to posit a circumstance here. You ask for records from a prosecutor that has to produce them within 15 and 30 days on the criminal procedure law. Instead, you get a denial letter. Give us 30 more days. Another denial
Well, you
letter.
get a constructive denial, you bring an action, and in fact, the remedy is, on a constructive denial, what's the remedy? Didn't you get the remedy you were entitled to? You got the documents. So at that point, when you get the documents and you're not satisfied with what you have, as my colleague is suggesting, isn't it your obligation at that point to say, to make substantive arguments with respect to why you're entitled to the documents that you were denied?
Your Honor, certainly we could have brought another action, and certainly I can bring another action for that matter. If we start this process all over again, I could do it on behalf of my client, or the family who lost a loved one could do it. Certainly we could start that all over again. But again, the position that you're adopting here, if you do that, you're
I'm not adopting any position. I'm just listening to argument.
Understand, but it's a carte blanche. They'll never reply. There'll never be accountability, because all they have to do is issue another 30-day letter.
Bring a petition for constructive denial, which you did, and you lost that, and then you got documents. So it's unclear to me. Are you arguing now that the documents that you got were insufficient?
We're not only arguing that our litigation brought about the record production, brought about an actual substantive decision after an appeal.
So you
We're saying it's
prevailed.
insufficient.
That's for attorney's fees, but I'm talking about the merits. Are you arguing that the production that was given to you was insufficient?
Yes, we absolutely.
Did you argue that below?
Absolutely.
And did you plead it in your pleading?
We did. And you know what, Your Honor?
When you did your petition, you didn't have any documents.
Correct.
How could you have pled that it was insufficient? You pled that this was a constructive denial, correct?
We pled it was a denial, a substantive denial.
Okay, whatever.
But how could it be on the merits when you got no documents?
Because we filed an appeal as this court requires, and then we had to move quickly. We unfortunately, if we didn't move according to this court's determination in again the Jewish Press versus New York City Department of Housing, we would be time barred. Again, this is an attorney seeking records. This is time and time again, electronically maintain records. There is no doubt that these folks could have gotten those records within 15 days as contemplated by the criminal procedure law, but they didn't.
So let's go to the issue of attorney's fees. Would you agree that it was a discretionary decision by Supreme Court?
This was mandatory. Otherwise, you eviscerate the statute. And I'll tell you why, Your Honor. If I understand my time is up, if you
Go ahead, go ahead.
Otherwise, you have no incentive to comply. You will simply issue these determinations over and over again. If this was a misdemeanor prosecution, which it was, right? 90 days have come and gone. It would be subject to dismissal.
But it wasn't that. So let's not do apples and oranges. And ultimately, at least from the record, it appears that the FOIL officer was working with your office, explaining what the issues were. So this is not a situation where there was like a willful refusal to comply.
Your Honor, they actually admit in their brief, quote, the hard copy file contained only a portion of the records that were available electronically. It couldn't be more clear, end quote.
No, but
That's the...
They talked about fewer people working during the pandemic in order to retrieve the documents, although they were electronic. And it's not like they blew you off. I mean, 2 days after they received the request, they send you an email saying, not everybody is coming to work, there are difficulties. I mean, they may have dragged it along a little longer than I would have been comfortable with, but...
And Your Honor's addressed that in Eustasher versus Clark, a 2021 slip opinion 5295, I believe. I know my time is up. If you like, I'd address further the willful violation.
That's okay. You can do that in reply, in rebuttal.
Thank you, Your Honor.
Thank you.
Good afternoon. May it please the court, Stephen Kress on behalf of the District Attorney's Office. There is only one issue on appeal, and that is whether the petitioner is entitled to attorney's fees. Whether exemptions were properly invoked is simply not an issue because he never raised that in the Article 78 proceeding. And he couldn't, I think, as Your Honor pointed out, he couldn't possibly have made an actual denial claim because at the time he filed his petition, there had been no actual denial.
Counsel, is there a different standard for whether or not counsel's fees should be awarded when there's a constructive denial versus an actual denial?
Yes, there is, Your Honor. In the constructive denial context, ultimately the decision to award fees is discretionary, whereas in the actual denial context, it's mandatory.
And how did the court appropriately exercise its discretion to deny it in this case? What's your argument why that was appropriate?
Well, I think for one, Petitioner's counsel has made an accusation of willful concealment throughout the course of this case, and I think is going to do that again in his rebuttal argument. Absolutely not true. And I think that's relevant to the court's exercise of discretion in terms of was the district attorney's office acting in good faith or were they willfully concealing things? Absolutely, we were acting in good faith here. Now, yes, it took longer than we would have wanted to ultimately get the hard copy file in this case. But from the very beginning, the RAO said, we're going to make a determination on this request. I'm waiting for the file. As it turns out, it would have been better if she had looked at the electronic records before that. But ultimately, she needed the hard copy file because she didn't know if everything in what was available electronically would also be in the file. So I don't think it ultimately would have changed the outcome. So we're acting in good faith. The petitioner has not identified any prejudice that he would have suffered about getting these documents when he did, as opposed to getting them a little bit earlier. And I'll also just point out the Beziaz case that we cite from the Fourth Department towards the end of our brief, which in that case, they upheld a court's discretionary decision not to award fees based on the circumstances of the pandemic. And here we had very short-staffed records office doing the best that they could. And it took longer than we would have wanted under normal.
But he substantially prevailed, right?
No, Your Honor. He did not substantially.
He got most of the documents that he wanted.
Well, that's not the standard, Your Honor, and I'll direct the court to Save Monroe Avenue, which is a Third Department case. And actually, this court has adopted the Third Department's discussion on this issue. It's not enough to just get a determination on your FOIL request. You have to show the reason why you got it is because you brought this lawsuit. And I think that makes sense. You shouldn't get attorney's fees for bringing a lawsuit that you didn't have to bring. And he didn't have to bring a lawsuit in this case. We had kept him apprised of the status of the request the whole time. The gears were in motion at this point. He gets a letter a few days before he files this lawsuit saying, we've got the electronic.
How long do you think he has to wait in order to bring litigation that will be the cause of you responding to the request in the first place?
So what the statute requires is that we are allowed to grant reasonable extensions. So it's a standard of reasonableness, basically. And so you have to look at that, the facts of each case to determine whether or not an extension is reasonable. And I think under the facts of this case, they certainly were. So, you know, you cannot just go on indefinitely taking, you know, saying, oh, well, I need another month, you know, you can't do that forever. Ultimately, that becomes unreasonable.
Well, presumably the pandemic ends in some fashion, right?
I'm sorry, what?
Presumably the pandemic ends in some fashion and the documents have to be turned over.
Yes, yes, of course.
Thank you, counsel.
Yeah, thank you.
Your Honors, if I may, I'd like to address the major contention I think here is that response are bound to the record or the lack of therein. That's what we're reviewing. The administrative record is they didn't assert exemptions. They didn't assert any of the things that they rely on now, like quote-unquote good faith. Your Honors are clear. How long?
But they notify you every time that they needed additional time, right?
They send the same form letter saying 30 more days, and they'll do it forever if you allow it.
Well, can we take judicial notice of the pandemic and its effect on institutions, both private and public in this country, and especially in this state?
Absolutely, and we put it in the record. These folks operated electronically, and that's how they produced records.
But you heard counsels, not completely.
Look, as soon as we sue, we get, quote, we will issue partial determinations on a rolling basis.
Right, so in other words, you got the remedy. You sued for constructive denial. While the suit was pending, you got the documents. So essentially what we're dealing with now is whether or not you should get attorney's fees and whether or not that the court exercised its discretion providently, correct?
No, Your Honor, because if that's the case, then this is a pattern that you will see. There is no incentive to comply with the law.
But it's constructive denial.
Your Honor, when we filed that appeal, that FOIL administrative appeal, and we seek to get those remedies, there's no recourse, there's no remand. I've argued this before in multiple courts, you know, through several judicial departments. The fact of the matter is, and again, I've argued before this court in Diaso Faustino, there is no idea that you could remand this. It's 5, 10, and 20 business days, not perpetuity, and this court has made that clear.
So we didn't go through a pandemic. What they're saying, they're acting in bad faith because the DA's office was not short-staffed, the people were working from home, et cetera, et cetera.
Your Honor, it's not in the record, and it's unreasonable because, again, the practice, in reality, the practice is that these folks produce electronic records all the time. It's belied by the obvious fact that my client, an attorney, once he paid $150, he didn't get the paper copies that they charged 25 cents a page.
Thank you, counsel.
Thank you very much.
Thank you both.
We thank the court for its kind consideration.
Last, People versus Sistrunk.
Good afternoon. May it please the court. My name's Elizabeth Vassley, and I represent appellant Mr. Eric Sistrunk. Mr. Sistrunk's waiver of his constitutional right to a jury trial was not knowing and voluntary because the court did not conduct a follow-up inquiry when an alarming red flag or signpost alerted the court to problems that triggered a duty to inquire. When the court asked Mr. Sistrunk if he was thinking clearly in waiving his right to a jury, he responded, "I haven't been getting sleep for the past couple days. I slipped and fell coming out of the shower unit yesterday." He never said yes, but instead, his answers pointed towards no.
He started talking about that he was under heavy prescriptions, and she did follow up and ask him whether or not his prescriptions were affecting him, I'm paraphrasing, today, right? And then he went on to say, well, that was last night when he took the prescriptions, not right now, not today, in terms of the time he was before the judge, right?
Actually, Your Honor, so she did ask him if he was on medications, and he said no, he was not on the medications, but that they prescribed him the medications the night before, but he had not taken them yet. And the court erred there by conflating her duty to make sure he was thinking clearly with whether he was on medications, because sure, sometimes people can be really off.
Well, I don't know that they got conflated. I mean, she asked directly to the defendant, are you thinking clearly today? And that's when he said that he had not been sleeping for the last few days. And then they engaged in that colloquy about whether he can make rational and thoughtful decisions. And the defendant said yes. The court asked him, are you on a heavy prescription right now? No, I'm not. You're not? So are you? Then the defendant said, that was last night. They prescribed it to me, right? So right now, 3:30 in the afternoon on October 22nd, are you under the influence of any medication right now? His answer is, no, Your Honor. I just woke up from a little nap. That's it.
He never answered that he was thinking clearly. And the medication question, you can also not think clearly if you're not on medications that you need.
So these are, I'm sorry to interrupt, but these are arguments you're making now. Did counsel at trial challenge the adequacy of the inquiry in any fashion?
It did not, Your Honor, but
So
that's...
it's not preserved, correct?
Preservation is not required in cases where there are these alarming red flags from the record.
But I haven't heard any alarming red flags from the record based on what my colleague the colloquy he just read.
It was alarming, Your Honor, because the judge never asked Mr. Sistrunk, are you thinking clearly, yes or no?
How does the written waiver that was executed, that comported with the statute, how does that play into your argument?
Because of the alarming facts in the record, and that is that he was saying he slipped and fell the night before. He could have a head injury. He never said that he was thinking clearly, and the court had to follow up, are you thinking clearly, Mr. Sistrunk, yes or no? And the court failed to obtain that answer. And the medications, that just... You can also be in so much pain you can't think clearly if you're not on your medications. There's people with mental illnesses that need their medications to be clear.
So, counsel, after that colloquy where she says, are you on medication? And then he signs the waiver after that, right? And his lawyer's right standing next to him when he signs the waiver, correct? It's after that colloquy that he signs the waiver.
The mere fact of
I'm just asking you, let's first just, right? She asks him these questions, his lawyer's right there, he looks at the waiver, and then he signs it. And his lawyer doesn't say anything about competency, correct? Even though there is this colloquy.
I believe he signs the waiver earlier.
No. I mean, I think he signs it after the colloquy.
Well,
and his lawyer's standing right next to him and could have said, Your Honor, I don't think and didn't raise any objection after that colloquy, correct?
That's correct, Your Honor, but it's not really the attorney's choice whether to waive or not. And he would not want to interfere with
We're talking about preservation, right? You're saying there was this huge red flag, and the lawyer's sitting next to him after he makes this statement and lets his client sign the waiver, and because of that, there's no preservation requirement. I just want to make sure that that's your argument.
That's correct, Your Honor, and a lot of cases, in plea cases and other jurisprudence, also say that no preservation is required in cases where there are these red flags in the record.
Right. Okay.
Thank you, counsel.
Good afternoon, may it please the court. David Gagne for the people. Defendant's claim regarding the voluntariness of the waiver did require preservation. Under People v. Johnson and its progeny, including many cases from this department, where a waiver meets...
Moving aside from the preservation issue, the follow-up questions, the inquiry that was required once the court was alerted to the fact that he had fallen and he was prescribed medication, was there anything lacking in the record in terms of the court's colloquy with the defendant before he signed the waiver?
No, there was absolutely nothing regarding what had occurred prior to that exchange.
Yes.
No, there was an extensive colloquy. The trial judge had given an extensive explanation of the nature of the right that he was waiving. The defendant said that he wanted a bench trial, not a jury trial. He said that on 2 separate occasions. The trial judge paused the proceedings so that he could confer with his counsel, and after he did so, he stated unequivocally that he wanted to go forward with a bench trial. More than that, the court was made aware of the fact that the reason that the defendant wanted to do that was because he had found out from his counsel that at his initial trial, the jury had voted 11-1 to convict. So the defendant's decision to go forward with a bench trial was extremely rational and calculated and entirely informed. And unless there are no further questions, I ask that you affirm.
I think we're good. Thank you.
What was required in this case was just the question, are you thinking clearly, yes or no? To get that answer, yes, from Mr. Sistrunk. That was all. And the court didn't do that. And that was error.
But you realize, you agree that there's no required catechism, right? I mean, the court will necessarily ask a series of questions just to try to determine whether he's competent to make the decision or not, or whether he understands what decision he's making.
There's no required catechism unless you have a case like this, where there is a red flag or signpost. And then there is this duty that's been triggered.
But it was pretty rational for him to have found out that the jury, there was only one juror that held, that prevented a unanimous decision of his guilt.
That was at the beginning of the colloquy, and this court and the trial court can't just cherry pick certain statements that seem to make sense when there was this red flag mixed in the middle. And because of that, in a case like Lopez, for example, if someone's pleading guilty and they say some things that make sense, like, yes, I did X, Y, Z, but then there is that Lopez red flag that negates the guilt, you can't just ignore that guilt, that issue, and try to say that other things in the record made that work.
I agree. It's late in the day, though, so I jump to conclusion.
If there's no further questions.
Thank you. Thank you both very much.
I did